Extremely urgent matter.
Don't mention any matter. I heard yesterday mentioning I allowed for 45 minutes. Sorry. Please do not mention any matter. Please call the list. Please call the list. Please call the list.
Extremely urgent.
Sorry. Yes, who is appearing in item number 1?
Extremely urgent matter.
Yes, who is appearing in item number 1?
Item number for the petition.
Yes, come forward. Place your case.
Can I deliver a little bit on the case? May I? The present case is that the petitioner gave an amount of a sum of 2 crore rupees with a promise that he will get returns on the basis of that payment. However, he didn't get any such payment after that, and thereafter he registered a
All matters which are urgent, file it, give presentation form, it will come as per presentation date. Yes.
Lordship, my mentioning was a little different, Lordship.
Yes.
My mentioning was a little different. Lordship had made an order, had given oral observation that not to take any coercive steps till 29th. We had not done so. Situation has arisen that we are 35-3, we are unable to serve. One of the petitioners has been taken into custody. We are unable to proceed, Lordship. That is the issue. If it could be
File an application.
There is no order. There is no order of your lordship that it was just an oral observation for your lordship that don't take it till the next date. Next date was fixed on 29th of June. Thereafter, matter was not taken up. That is the issue, lordship. If some
will keep sometimes next week, I will
lordship. Very well,
lordship. Then
hold your hand for some time.
Yes, lordship. Yes. Very well.
Thereafter, we filed a written complaint, and FIR was not being registered. But however, the FIR got registered recently. After
FIR is not registered.
FIR got registered recently.
It has been registered.
Yes.
So your grievance is redressed.
Yes.
Learned advocate representing the petitioner submits during pendency of this petition, FIR registered by the concerned police authority and grievance of the petitioner is redressed. Next paragraph, state respondents are represented by learned advocates. Next paragraph. In view of efforts and submission made on behalf of the petitioner, writ petition is disposed of. Submission on behalf of the petitioner, no further order need be passed on this writ petition and writ petition is disposed of. Parties to act on the server copy. Next.
Item number 2.
I'm for the petition. This behavior service. We were served earlier on the last occasion. Your lordship adjourned this matter for the as the private respondents were not appearing, but it is showing served. But
yes, when you have served upon the private respondent.
On 20th June. 20th June.
Place your case.
The private respondents are disturbing the petitioner and not giving her to construct her building and also the boundary wall. There is a specific injunction order also. Still, they are disturbing. The petitioner has purchased her land. The petitioner is an old lady. And she has purchased her land when it is.
Where is your complaint?
Lordship?
Where is your complaint? It is page 30.
30, yes. Complaint against the local.
Just a minute. So construction of boundary wall
Yes, your lord.
on the land.
Yes,
So
sir.
the local club is creating disturbance. Now you have to approach the appropriate authority.
Yes, my lord, we have approached my lord, officer in charge, but still we have.
No, officer in charge is not the appropriate authority to decide the interstate right of the parties. You have to approach the civil court. And if you want to raise construction by making boundary wall, by erecting boundary wall, in that event, approach the panchayat authority or the local municipality. What police authority will do? If there is any order, then police authority can take steps. Otherwise, police authority is not the appropriate authority to decide the interstate right of the parties over the land in question.
There is a specific injunction order. We have stated that in the.
Yes,
There is a specific injunction order also.
injunction order by the suit court, by the civil court,
But that
in a
is,
suit instituted by the petitioner.
no,
Then, where is that order?
but
Next one.
So that is not part of record. Issue. Affidavit of service filed on behalf of the petitioner is taken on record in spite of service of notice. Respondents are not represented. Private respondents are not represented. However, state respondents are represented by Mr. Das, learned additional government. Next paragraph. On going through the complaint dated 8 June 2026 of the petitioner. Complaint dated 8 June 2026 of the petitioner lodged with the concerned police station. It appears that petitioner is aggrieved by obstruction made by the private respondents. As a result whereof petitioner could not raise boundary wall or could not construct boundary wall. Stop. Private respondents are not could not construct boundary wall. Stop. Private respondents are not represented today. Could not construct boundary wall. Next paragraph. Demarcation of land is necessary. Next paragraph. Having considered the submissions made on behalf of the petitioner, it appears that if petitioner is prevented from constructing boundary wall, in that event, petitioner is required to approach the appropriate forum / authority in pursuit of remedy. So police authority is not the appropriate authority to decide interstate right of the parties over the land. Stop. Next paragraph. However, concerned police authorities are directed to maintain peace and tranquility at a local and to see that no untoward incident takes place. Petition stands disposed of. Urgent direction. Next.
Grateful, Lord. Item number 3.
Lordship, in item number 3, I appear on behalf of the state respondent. I am being led by learned GP.
State respondents.
My lord, I'm for the state led by learned GP, my lord.
Yes. You are appearing for the private respondents. Yes.
My lord, the case is this, that private respondent illegally grabbed my property, of which I am the lawful owner. And when I have approached the police authorities to take legal steps against them, they have not registered the FIR. Even private respondents are threatening me so severely that I may have to someday, in future, I have to leave my house and house.
Yes. What is
etc.
your submission?
My lord, the writ petition is not maintainable, my lord. This is absolutely a civil dispute. My lord, the private respondents are the legal heirs of the, they are the descendants, they are the grandsons of the deceased holder, my lord. And my lord,
No, how private respondents are involved in so far the land.
but private respondents are the grandsons. They are cultivating in accordingly, my lord, in the land, my lord. So
Cultivating land.
they
It's
are
an agricultural land.
agricultural land. They are cultivating, my lord, and they are the grandsons.
Affidavit of service filed on
This writ petition is not at all maintainable, my lord.
affidavit of service filed on behalf of the petitioners are taken on record. Next paragraph. It appears from the submission made on behalf of the petitioner that private respondents are obstructing the petitioners from enjoying peaceful possession of the land in question, which prompts the petitioners to approach this court with the present writ petition, seeking direction upon the concerned police authorities to take steps. Next paragraph. However, the submission made on behalf of the petitioner is disputed by the learned advocate representing the private respondents. So it is submitted that private respondents have a right to cultivate the land in question. Next paragraph. State respondents are represented by learned. Where is Mr. Where is GP?
My lord, he's on the way, my lord.
State respondents are represented by learned advocates. Next paragraph. Having considered the respective submissions made on behalf of the parties, it appears that the issue involved in this writ petition is civil in nature, requiring the petitioner to approach the civil court in pursuit of remedy. Police authority is not the appropriate authority to decide the inter right of the parties over the land in question. Stop. Writ petition. Next paragraph. Writ petition has dismissed parties to act on the several topic. Grateful. Next.
Grateful, my lord, grateful.
Right.
Item number 4.
Court, my lord, I appear for the private respondent.
My lord,
Yes, who is for the petitioner?
my lord, I am for the petitioner. My lord, this is my affidavit service. I have served. My lord, before starting, my lord, may I place the case in short, my lord? My lord, actually, my
What
lord,
you are praying for?
What?
What you are praying for? So in and around the premises of 74 Rohim Ostakar Road,
my lord, it is
Kolkata
a mandir.
45, there are disturbances.
My lord, it is
Yes.
a mandir.
So what police authority will do?
My lord, what police authority has doing, my lord, that I am placing fast, my lord. My lord, it is a mandir, is in existence since 70 years. Last 70 years. It is a mandir of, my lord,
So paragraph
Radha Govinda Mandir, my lord. My lord, kindly come to page number 51. My lord, certainly, my lord, I received 144 order, my lord, that is 163 order, my lord. My lord, kindly come. My lord, may I read?
144 order is or 163, 165 BNS. These are only to maintain peace, nothing
Peace and
else.
tranquility. My lord,
Yes.
what is happening,
So
my lord?
why you are
Why
before the
virtue-
read court?
why-
Why you are before the read
My lord,
court?
may I submit it? My lord, by
Be
virtue of
precise.
my
Yes.
in precise. My lord, by virtue of this order, my lord, I am not even enter into the mandir, my lord. My lord,
Yes.
I am not allowed to enter into the mandir.
So the police authority will enter into this issue and make the way for your entering into the mandir. There must have been dispute between the parties with regard to Seva Puja or other things.
My lord, no.
Yes,
nothing, my lord.
Mr. Mukherjee, what is your instruction?
Lord, I am the owner in respect of this property, my lord. I have the deed. They are trying to grab my property, my lord, on the pretext of, my lord, a
Not at
mandir.
all, my lord.
But I
So
can
whether
show
they-
you the photograph.
You are required to approach the civil court.
Yes,
What
they are
police authority will
My
do?
lord, what is happening? My lord, kindly.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It is submitted on behalf of the petitioner that he is being prevented from entering into a temple in question, denying his right.
Self-contradictory papers.
Denying his right. Stop. Prayer is made in this writ petition for a direction upon the concerned police for direction upon the concerned police authorities to take necessary steps which would facilitate the petitioner to enter into the temple in question. Next paragraph, Mr. Probal Mukherjee, learned senior advocate representing the private respondents, has opposed this writ petition on the count that petitioner that the private respondents
Seven.
that respondent number 7 is having right to having right over the temple in question, and
The
in this
land,
regard-
land,
not temple.
No, owner of the land.
তাহলে land করে দাও। Having right over the land in question, and in this regard, reliance is placed on a deed.
Deed of the year 1953.
Deed relating to the said land. Next paragraph, state respondents are represented by land advocates. Next paragraph, having considered the respective submissions made on behalf of the parties, it appears that petitioner and respondent number 7 both are respondent 7 are claiming right over the land in question, requiring the parties to approach civil court. Requiring the parties to approach civil court. Stop. Police authority is not the appropriate authority to decide the interest right of the parties over the land in question. Next paragraph. Hence, no relief can be granted to this writ
My
petition.
lord, my lord, one thing, my lord. In the meantime,
Agreed.
what are they? What are they trying to, my lord?
Next.
My lord, they are trying to construct a wall, my lord.
Next,
My lord, kindly-
you approach the Kolkata Municipal Corporation in that event. Yes.
Item number 5.
Lord, in item number 5, we are led by Mr. Majumdar. I am requesting learned additional advocate.
Yes.
My lord, I'm requesting for a
Rajiv Majumdar, yes, yes.
I'm requesting for a passover, my lord. He is on legs in some other court.
Well, may I make one request, my lord? Instead of Passover, if your lordship may keep it tomorrow with an additional prayer. But here, my lord, I have challenged 11 FIRs, all of 2026.
Mr. Dotto, let it be on Monday.
Monday,
Because certain urgent matters are fixed tomorrow. And there will be come back on Monday.
may I pray for, my lord, one direction? I think that will harm nobody.
Thursday and Friday, this court has difficulty.
Very good. May I make one prayer? But let Mr. Majumdar, my lord, on the next day, whichever date your lordship is pleased to fix, bring a list of all the FIRs that have been registered against me. This is a prayer which I'm making. I don't think about
List of FIRs.
list of all the FIRs. As of now, every day we come to know of 2, 3. This I don't think.
Let me pass a short order.
Yes.
A matter is heard in
But
presence of
only difficulty is
you hear the order. Matter is heard in presence of the learned advocates representing the petitioner and state respondents. However, on behalf of the state respondents, accommodation is prayed for on behalf of Mr. Rajiv Majumdar, learned additional advocate general. Next paragraph, Mr. Kishore Dotto, learned senior advocate representing the petitioner, prays for a direction upon the concerned police authorities to produce list of FIRs drawn up against the petitioner. Next paragraph, concerned police authority is directed to file a list of FIRs drawn up against the petitioner on the next date. Hearing of this matter stands adjourned. Acceding to the request made on behalf of the state respondents, list the matter under the same heading for further consideration on July 2026.
But only one, I'm sorry, but I should have pointed it out earlier. But there are a few cases in which I am not named but wanted. If that can also be,
let them come back with a report. Let me see.
But another request is, I have filed another writ petition praying for quashing of 4. If that could be tagged with it, because the same petitioner, same petitioner.
Whether it is appearing in the list?
No, it was filed, during vacation. Then it did not appear in the list.
Well, let me take up your matter. Yes.
Rather, that was made at an earlier point of time. This is at a later point of time. Very good.
Item number 6. 6, my lord, I am for the petitioner, my lord.
My lord, I am the
For the private respondent number 7.
This is affidavit of service, my lord.
Who is for the petitioner?
Madam, I am for the petitioner,
Yes.
my lord. The agreement for, my lord, I am
Private
respondent.
Yes.
the petitioner being the promoter. Out of an agreement of 2013, he was constructing the property. Time and again, he has been interrupted by the landlord's son. So as to project is not completed and he is ousted from the property. But I've invested much of money.
To do?
My lord,
What police authority has to do?
but they will prevent them from stealing the goods lying there. I have complained regularly. My complaints are there. Only to just see the complaint to inquire so that these things can be stopped.
Now, if your complaint has been transformed into an FIR,
No.
so then approach the appropriate authority.
But I should be protected there.
Approach the appropriate authority, jurisdiction magistrate under section 175(3). What police, today, what writ court will do? There is an alternative remedy available.
But if these things are being done, my lord, police will remain idle tight. And in this matter, my lord,
Instead of approaching this court,
My
you
lord.
ought to have filed an application under 175(3). Have you approached under section 173(4)?
complaints. Well,
First,
complaints.
you have to approach under section 173(4). Where is the approach?
Well, that is
Show
the
me.
175(3) your lordship is asking about.
Show me.
The problem is there, my
Let
lord.
the remedy under section 173.
These things are going on.
Any person acted by refusal on the part of the officer in charge of a police station to record the information, so and so may send the substance of such information in writing by post to the superintendent of police. Have you done so?
But earlier there had
I am
been
asking you, have you done so?
earlier there had been FIR. Your lordship kindly come
This case is concerned, have you done so?
connecting to this property.
Yes.
Kindly come to page 40. There had been FIR. Your lordship kindly come to page 40.
There's a recent judgment in 2026, January.
Matter is hard in affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Having considered the submission made on behalf of the petitioner, it appears that petitioner is being, having considered the submissions made on behalf of the petitioner, it is found that there is an allegation made by the petitioner against the private respondent. As a result whereof, petitioner is finding it difficult to raise construction pursuant to development agreement, pursuant to development agreement. Stop. It is also submitted on behalf of the petitioner that a complaint is lodged with the local police station, but there is inaction on the part of the concerned police authorities. Stop. Learned advocate representing respondent number
7 and 8.
learned advocate representing respondent number 7 and 8 and learned advocate scholar representing respondent number 7 and 8 and state respondents have jointly submitted that there is an alternative remedy available to the petitioner in the event there is inaction on the part of the concerned police authorities after lodging complaint with the local police station. Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties, it appears alleged inaction on the part of the concerned police authorities prompts the petitioner to approach this court with the present writ petition. Stop. If petitioner is aggrieved by inaction on the part of the concerned police authorities, in that event, petitioner is required to take steps in terms of section 173 within bracket 4, as well as 173 within bracket 4, and there is further remedy available under section 175 within bracket 3 of BNSS 2023 by approaching jurisdictional magistrate. Next paragraph. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC online SC 798 within bracket Sujal Bishwas Attawar and another versus state of Maharashtra and others. Next paragraph. Hence, next paragraph. In view of availability of alternative remedy, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach the jurisdictional magistrate in pursuit of remedy. Parties to act on the server code. Next.
One submission, my lord, lordship kindly record on my behalf, my lord. My lord, lordship on same day, same facts and circumstances.
Next matter.
Item number 7. To petitioner, my lord, it is my affidavit of service, my lord. My lord, here the state petitioner is the wife of the private respondent, and private respondent fled from his wife and misexecution, and one miscase was filed for maintenance, and several warrant has been issued, and the said private warrant was issued by the said execution.
Any criminal prosecution is pending?
Yes, my lord.
By registering FIR?
No, my lord.
No, lordship, this is a 125 maintenance case.
Yes, my lord. Here,
And thereafter,
125, there is an order.
There is an order. The private respondent has not complied.
Cannot be executed.
Yes, private respondent has not complied. That's why under
You are
section
applying for the state.
I am applying for the state.
My lord, here several times personal appearance of the police was made.
See, you have to approach within the statutory framework.
Yes, my lord.
As it has been decided by the Supreme
Yes, my
Court,
lord.
writ court is not the appropriate
No, my lord.
authority to
Here-
decide all these things.
Here we are saying one direction as the said private respondent is residing within the said jurisdiction of the police station. Police every time giving the
When the order warrant was issued,
warrant from 2018 still date. Police
so
cannot.
2018 warrant of filing a
Yes,
writ
my lord.
petition in
My lord,
2026,
several
it is to be
my lord, kindly cease. Several personal appearance of the OC. OC never come.
Lordship,
My lord, it is the
kindly go
certified
through.
copy. Said private respondent married there, residing there. This is the voter list, my lord,
Another wife.
of the wife and the said private. But the warrant cannot be executed in 8 years.
দুটো বাচ্চা আছে।
চুপ কর না, কথা বলবি না এরকম।
Several raids were made.
Yes.
Steps were taken.
He is residing there.
This is a premature stage. Kindly. Everybody has not been exhausted.
List, my lord, he is residing there.
Next paragraph. But why he is not being found out? His wife, father, mother, all were interrogated.
Lordship, they have already tried.
And as a result whereof 125 proceeding is being frustrated.
He is not deciding over there, as per their report.
No, my lord,
Leaving
it is
aside
the
his
voter.
wife and parents.
Yes.
Yes.
Wife,
wife,
parents, they have been also been
You
asked.
make a further attempt. Because otherwise these proceedings will be frustrated.
Lordship, in my respectful humble submission, Lordship,
Police
there will
cannot nab a warrant.
that's why he will have to approach
on 125 proceedings and his family members are residing there.
before
Who will
the
believe it?
jurisdictional magistrate. Lordship.
Yes, my lord.
There are proclamation.
Don't take in all matters technical point. This is an issue where 125 proceeding is pending.
Lordship.
Warranty has married again. And 125 proceedings at the instance of the petitioner is being frustrated since the warrant is not being executed.
Last they have
Police station.
Domjur. They have lastly searched on 2nd of this month. And the next date of the jurisdiction has fixed on 30th July.
Affidavit of service filed on behalf of the petitioner is taken. It is under section 125 CRPC proceedings.
Yes.
When the warrant was issued 2018.
2018, my lord. My lord, several times the court have. It is the voter residing there, my lord. Several personal appearance of the OC was made.
A learned advocate representing the petitioner submits in a proceeding under section 125 CRPC. One warrant of arrest was issued against respondent number
4.
Private. 4.
Against respondent number 4.
4.
Yes, my lord.
4. Long back. But said warrant of arrest could not be executed. Stop. Several orders were passed by the court below, directing the concerned police authorities to take necessary steps for execution of warrant of arrest. But that did not yield result. Stop. Finding no other alternative, petitioner being the wife of, claiming to be wife of respondent number 4, has approached this court with the present writ petition for execution of warrant of arrest. Next paragraph. Officer in charge, Domjur Police Station, being respondent number 4. Now, next paragraph. Learned advocate representing the state respondents has filed a communication dated 13 July 2026 of Inspector in Charge, Domjur Police Station, Howrah Police Commissionerate, and same is taken on record. It is a copy of the said communication dated 13 July 2026 is made over to the learned advocate representing the petition. Next paragraph. It is disclosed in the communication dated 13 July 2026 that steps were taken, but warrant of arrest issued against respondent number 4 could not be executed. Next paragraph. However, having gone through the said execution, communication dated 13 July 2026 of the concerned police authorities, court is not satisfied, and it is found Inspector in Charge, Domjur Police Station, is directed to take immediate steps for executing warrant of arrest and produce the respondent number 4 before the which court?
Third JM Barakpur. Third Judicial Magistrate Barakpur.
Third
Judicial Magistrate Barakpur.
Third Judicial Magistrate, Third Court, Barakpur, North 24 Parganas. Stop. This court expects that necessary steps shall be taken by 4 weeks from date. Next paragraph. Hearing of this matter stands adjourned. Inspector in Charge, Domjur Police Station, is directed to file further report disclosing the steps taken in terms of the order passed by this court. In terms of the order passed today. Next paragraph. Hearing of list the matter under the same heading for further consideration on August 27th, 2026. Next.
Item number 8.
Yes.
With regard to post-poll violence, on the day of declaration of the result, the private respondent assembled in the house of the petitioner and thereafter assaulted the petitioner and family members.
Effect has gone.
Your lordship has also.
Now situation is normalized. Go back to your residence.
We are out of house.
And if necessary, police authority will take.
This order has been passed by your lordship.
Election result was on 4th of April, May 2026. We are today in the mid of July. I don't think there is any further difference.
Lordship, we just need the police assistance to return our house. This is the order passed by your lordship in an earlier matter.
After my learned friend submits, lordship, I will make certain submissions.
Yes, make your case. Make out your case.
Lordship.
Don't rely upon this order because this was order. This order might have been passed on on separate facts.
Facts are identical. Madam, kindly come to page 17. My complaint.
Yes.
This is the complaint lodged by the petitioner number 1. They have demanded 5 lakh rupees so that the petitioner can stay in their house.
Now, still till date, petitioners are not staying at
out of their house. And my lord, an identical issue, my lord, the Honorable Division Bench has passed an order that starts from, my lord, page 25.
Now, whether the FIR has been registered?
That information I don't have.
You do not know. Yes, FIR has been registered.
If he has completed lordship, now I will make some.
Yes.
12th of June, he sends an email stating that certain allegations have been made out. Police registers an FIR. FIR has been registered. In local inquiries conducted, statements of disinterested witnesses are taken. Such allegations are not substantiated. Nothing happened. Why this writ petition has been filed is because the petitioner number 2, there are certain cases pending against the petitioner number 2.
Criminal prosecution.
Criminal prosecutions pending from on basis of what?
You have disclosed it.
Today, he has claimed that post-poll violence. All the cases registered against him are because of the post-poll violence that he had done back in 2021.
Yes.
That will
Where
take,
you have disclosed it.
Where are these disclosures?
that information I
Where
don't
are the
have right
disclosure?
now.
Otherwise, I will dismiss it with exemplary cost.
But kindly
Because
allow me.
this determination is being misused by the litigants rampantly.
If he says that he does not know it, charge sheet has been filed on those cases. Cognizance of charge sheet has been taken.
Now post-poll violence story.
But now this is,
I have rightly pointed out at the beginning, Mr. Mojumdar,
Lordship, this is
that
not
that
a story. These
effect
facts-
is over. Now
facts
there
are
is no
happening.
post-poll violence. If there is, yes, there are stray incidents might be that court will take into consideration. But this, see the position. You are not aware of the proceedings which are pending against the
But
petitioner
I
number
can
2.
disclose it by a supplementary petition.
No, not at all. You have not come up. You have not come with clean hands.
This is not a
You have
concocted
not come
story.
with
These
clean
things
hands.
are happening, Lordship.
Where is the disclosure in your writ petition?
That I have, that information I don't have, but I
You are
can
an accused
disclose it.
person in other criminal proceedings,
if the
and
charge sheet- if the
and
charge
the
sheet
police
has been-
authority is going to provide you protection.
Well, if
4
the charge sheet
cases.
has been filed,
4
then
criminal
the court will
cases.
take its own course.
4 criminal cases, 4 charge sheets. Cognizance has been taken of those charge sheets.
Found me-
Now
found
these
me not accused.
concocted stories are being framed, and litigants are coming before this court
No, but
in
there
order
is-
to
An
get the
example
benefit.
needs to be set out, Lordship. Let exemplary cost be first imposed. He wants to go back home, the police will render all assistance. First, an exemplary cost be imposed.
A criminal case has been lodged
Where
against
is
me.
the disclosure? Where is the disclosure that he is accused in some other proceedings where charge sheet has been filed?
I have to collect all details and bring it
You have to
before
collect
Lordship.
now after the point is raised by other side. This is your bona fide.
But
Mr.
kindly-
Mojumdar, this is your bona fide.
But kindly appreciate one thing. So far,
What
petitioner has got
appreciation
one
you
case
want, you
allegation.
expect from this court? This is your conduct that you are accused in four criminal prosecutions, and where charge sheet has been filed. Have you disclosed it that these criminal prosecutions are pending against you?
But that has not been disclosed. I cannot develop my case at this stage, but there is no allegation against petitioner number 1 first.
Issue.
And my lord, that doesn't mean that the petitioner have to stay out of their house only because the criminal case is
Affidavit of
pending
service
against him.
filed on behalf of the petitioner is taken on is taken on record. Next paragraph, it is submitted by the learned advocate representing the petitioners that petitioners are a victim of post-poll violence as a result whereof petitioners praise for direction upon the concerned police authorities, which would facilitate the petitioners to lead normal life by normal life by residing at their respective premises. Next paragraph, stop. A complaint has been lodged in this regard, which now attention of this court is drawn to undated complaint.
No,
Page 17.
have it. Page
It
Where is
was
the date?
sent on 12th of June. That is an admitted position.
Where is the date, Mr. Mojumdar?
Well, that date will
Ah.
your lordship will get at page 19, the email.
Based on which FIR has been registered.
FIR has been registered against 19 persons.
That is Jibontala PS case number 651.
1 of 2026.
6 July 2026.
2026. Thereafter, Lordship, the next paragraph is also important. Nothing came out. These are all concocted stories. One is pending investigation, 3 charge sheets submitted. Cognizance taken of all.
And this fourth paragraph, these are the first, second, third, fourth, fifth, in sixth paragraph, these are the prosecutions
Pending against him.
Respondent number 2.
Respondent number 2. Petitioner number 2.
Petitioner
Petition
number 2. Yes.
Son of petition number 1.
Yes. Son of petition number 1.
Son of petition number 1.
তাহলে ওইখানে একটু চেঞ্জ করো বলো তো।
No, Lordship.
No,
Not son.
Bappa Naik is the son of Nipen Naik.
Nipen Naik, sorry.
And petition number 1 is a different person.
Next paragraph. ওটা কেটে দাও। Attention of this. Mr. Das, learned additional government period representing the state respondents. has filed a communication dated 7 July 2026 of officer in charge Jibontala Police Station, and same is taken on. Stop. It is disclosed in the communication, in the said communication, that based on the complaint lodged by the petitioners, which is at page at page 17 of this writ petition, an FIR was a criminal prosecution was initiated, being Jibontala PS Police Station case number 651/2026 dated 6 July 2026 under certain provisions of BNS 2023. However, in the same breath, it is also disclosed in the said communication that there are 4 criminal prosecutions pending against the petitioners, against the petitioner number 2. And allegation is a petitioner number 2. Petitioner number 2. Stop. It is submitted that in in all 4 criminal prosecutions, Mr. Das, charge sheet has been
The case which is Jibontala PS case number 494 of 26, investigation is going on. The rest 3 charge sheets have been submitted. Cognizance has been taken.
It is also submitted, excluding Jibontala Police Station. No, there are 4 criminal prosecutions.
Yes.
Yes, first one is 494 where investigation
is still undergoing.
আচ্ছা, আগের যেটা বলেছিলাম সেটা কেস নাম্বারটা কি বললাম, যেটা রাইট কি বলছিলাম, excluding criminal prosecution being Jibontala Police Station case number 494/2026 dated 11 June 2026 in 3 other criminal prosecutions as disclosed in the communication. Charge sheets have been filed against the petitioner, or charge sheets were filed against the petitioner, comma, in Jibontala PS case number 494 of 2026 dated 11 June 2026 is investigation is going on. Stop. Next paragraph. On posing query to the learned advocate representing the petitioner, it is found that pendency of 4 criminal prosecutions as disclosed in the communication dated 7 July 2026 against petitioner number 2 are not disclosed in the writ petition, and prayer is made in this writ petition to provide protection to the petitioners since they are victim of post-poll violence. Next paragraph. Next paragraph. Non-disclosure of criminal prosecutions, non-disclosure of 4 criminal prosecutions pending against the petitioner number 2 goes to show that there is suppression of material fact on the part of the petitioners, and petitioners have not approached this court with clean hands. Stop. However, based on the complaint lodged by the petitioners, as it is found that FIR has been drawn up, being Jibontala PS case number 651/2026 dated 6 July 2026, comma, concerned police authorities are directed to take steps to take the criminal prosecution to its logical conclusion. Stop. Next paragraph. Writ petition stands disposed of. Urgent xerox certificate. Grateful.
So for that petition number
Nothing.
1 is concerned, there is no allegation against him.
Nothing.
I'm grateful.
Item number 9.
9, I beg to appear for the respondent number 6.
Lordship, I'm the petitioner in this case. I'm led by Mr. Mukherjee in this matter, Lordship.
Yes.
I'm led by Mr. Mukherjee in this matter, Lordship. Yes. That's my affidavit of service. Lordship, I had applied for a job, Lordship. My experience after joining the job in January, Lordship, I am terminated from that job. I am told that my experience certificate has been forged. On the basis of that, my job has been terminated. Now, Lordship, we had preferred an application for restoration, for basically reinstating.
Reinstatement.
for reinstating my job in that company, Lordship. For that, the matter is pending before Honorable Justice Ritobroto.
Justice,
Lordship, Court 18.
don't say court number. Before
Lordship,
which
Honorable
court?
Justice
This is
Ritobroto
not the
Mitro.
appropriate submission. You are practicing for quite for quite some time.
Lordship, Honorable
Don't
Justice
say court
Ritobroto
number so and
Mitro.
so.
I-
Yes.
Honorable Justice Ritobroto Mitro, Lordship.
Yes.
Lordship, he had directed the state to call for a report asking that on what basis they have come to the conclusion that my experience certificate was forged and they have terminated me from my job. That matter is kept on 27th, Lordship, 27th of July. Now, Lordship, in this case, we have prayed for, we had registered a complaint, Lordship, and we had prayed for the progress. My only humble prayer before your lordship is to keep the matter after 27 so that the report which the state submits in before Honorable Justice Ritobroto Mitro stating on
The
which
report
ground
is to be submitted by the employer in that matter,
lordship in
not
that
by the police.
lordship
Because that is a service matter.
indeed lordship, but they lordship there this police is not a party, lordship.
Yes.
The company
Here
which
you have made a lodged a complaint that you must have lodged a complaint. here.
indeed lordship we have lodged a
With
complaint.
regard to the finding of the concerned party that your experience certificate is forged.
Indeed lordship we have
Therefore, the police has not taken any steps. You have approached this court.
Indeed, Lordship. Lordship, one more thing that there, before Honorable Justice Ritobroto Mitro, the matter, he had directed for a
Here
report.
the honorable court taking service matters will consider whether it is an appropriate case for reinstatement or not.
Lordship, reinstatement issue I am placing before the honorable bench. My only humble prayer here is that the report which the state would provide there, the state respondents would provide there with respect to ascertaining that why they have come to this conclusion that my experience certificate was forged, because I was under the genuine apprehension that
What you have prayed for here?
Lordship,
Station away by here.
Lordship, Lordship, I have prayed for progress of investigation, Lordship, because
How
I
this
had
maintenance
given.
in view of the recent judgment. You know very well. You are
Lordship,
doing matters before the court.
That is called spin doctrine. Spinning it around.
Lordship, my
That's why Mr. Mukherjee is not appearing.
Lordship, Mr. Mukherjee is in court number
Very well,
237, Lordship.
very well,
He's on
but,
his legs.
Here the issue is completely different. Here you have prayed for a direction upon the concerned police authorities for taking the investigation to its logical conclusion, taking forward your investigation by in accordance with law. If that is so, then the writ petition is not maintainable. You have to approach the jurisdiction magistrate.
For that to be ordered,
And whether the FIR has been registered.
no, that is the issue, Lordship. Step 1 has to come before step 2. Progress of
Lordship only
investigation is
keeps this matter after 27 so that once we can place the report which has been given.
Learned advocate representing the petitioner submits that learned advocate representing the petitioner prays for accommodation since matters relating to service of the petition is pending before a coordinate bench and same is scheduled to appear on 27th.
Indeed, Lordship, this order.
देखिए दो सेंस नंबर पढ़ो तो now since another writ petition being WPA 14932 of 2026 relating to service of the petitioner is scheduled for hearing on 27 July 2026 before a coordinate bench. Next paragraph, state respondents are represented by Mr. Das, London Additional Government Leader. Stop. Next paragraph, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on this is on 27th
July.
10th August 2026.
grateful.
Much obliged.
Yes, next matter.
Item number 10.
Then Lordship, I am for the petitioner. I am for
my
the
affidavit
affidavit
of
number
service.
4 to 10, 11.
Yes, you are for the petitioner.
I'm for the petition. Lordship, this is an application praying with, against the police inaction in respect of a FIR filed in the year 2022. Still the FIR is pending. No progress has been made. Now the crux of the matter is my father was a
For
established
the state. Now I am for the respondent number
Private
4 to 11.
respondent.
Private respondent.
And I-
4 to 11. 4 to 11.
And I am for the state.
now the private respondent.
So you are agreed with regard to inaction of the police authorities since there is no considerable progress in the investigation.
No progress whatsoever.
So therefore you need to approach the
I have
appropriate
already
authority.
approached the Honorable Judicial Magistrate several times. IO reports has been called for, but still no progress has been made. 5 times IO has been changed, but still no progress. Why my grievances are, my father already died during the investigation. My case was filed in 2022. My father died in 2023. Now all his property was sold out within the corona period of 2021. And very strangely, all the 7 or 8 deeds.
Is it your case that you are agreed by the order of the jurisdictional magistrate?
It is my case that I am not aggrieved, but I am aggrieved by the police inaction in
If
regard
you are
to this.
agreed by the jurisdictional magistrate, then there is an
There's a different forum. I am not going into that. My grievance is in respect of non-progress of the
affidavit of
Moreover,
service
I
filed
am
on
being
behalf of the
continuously
petitioner is taken
forced.
on record.
So I'm
Next
also
paragraph.
praying that some protection may be provided to me.
The petitioner prays for a direction upon the concerned police authorities.
4 years,
Necessary
nothing done.
steps in connection with the criminal prosecution initiated based on the complaint lodged. Stop. It is submitted that in Asansol North Police Station, case number 363.
363 of 22.
363 of 2022.
Dated
19/8/2022. By this time, necessary steps should have been necessary steps could have been taken by the concerned police authorities, but inaction on the part of the police authorities prompts this petitioner to approach this court with the present writ petition seeking necessary direction. Necessary direction. Next paragraph, state respondents and private respondent numbers
4 to 11.
4 to 11 are represented by learned advocates who submits that there is alternative remedy available to the petitioner under section
Lordship, if
175,
I may.
175 under section.
Lordship, if I may, the alternative remedies that your Lordship is. Lordship, that has already, I have already filed an application under 156(3). Thereafter, my complaint was taken up and FIR was drawn. I have approached the learned magistrate several times. Now, I am praying here that I am getting continuously coerced.
Show me that order where the orders passed by the magistrate.
Lordship.
Then you challenge those orders.
Lordship, the order is for calling for IO report. What is to challenge? They are not doing anything. Where is my remedy? The learned magistrate is continuously asking for report. No report is being submitted. Only this jurisdiction can help me out.
CRPC, which corresponds to 175(3) BNSS 2023 by approaching jurisdiction magistrate. Next paragraph. It is succinctly decided by the Honorable Supreme Court.
Kindly record my submission. I have already availed of that.
It is succinctly decided by the Honorable Supreme Court that
the Honorable Supreme Court has also held
in the
not
judgment
taken.
reported in 2026 SCC Online SC 798 within bracket Sujal Vishwas Attavar and another versus State of Maharashtra and others.
Kindly see the circumstances, Lordship. Even the Honorable Apex Court has held in these circumstances, the Honorable Court should interfere. After 4 years of running from pillar to post.
Registering FIR, if proper investigation is not being carried out, then remedy does not ordinarily lie in invoking the writ jurisdiction in the first instance. But in seeking recourse to the in seeking recourse to the statutory framework, party has to approach under the statutory framework. Unless, of course, urgency of the circumstances warrant otherwise. Next,
Lord, I'm relying upon that judgment.
it is submitted on behalf of the petitioner that petitioner approached jurisdictional magistrate under section 156(3) and several orders were passed. Stop. However, no submission is made on behalf of the petitioner raising grievance against the order passed by the jurisdictional magistrate. In proceeding under section 156(3), que 175(3). Stop. If petitioner is aggrieved by the order passed by the jurisdictional magistrate, in that event, petitioner needs to approach the appropriate forum by initiating a proceeding. Petitioner is required to approach the appropriate forum by initiating. Petitioner is required to approach the appropriate forum by initiating proceedings in accordance with law.
Would you kindly allow me 1 minute?
Note of the submissions. Now, taking note of the observations made by Honorable Supreme Court in Sakiri Vasu versus State of Uttar Pradesh and others, reported in 2008, Volume 2, SSC 409. In paragraphs 11, 12, in paragraph 11 and 25, paragraph 11, 25, 26 and 27, as well as the observations made by the Honorable Supreme Court in paragraph 7 of Sujal Vishwas Atava Sutra. This court is not inclined to interfere in this writ petition by giving direction upon the concerned police authorities to take certain steps for in connection with aforesaid criminal prosecution. However, this order shall not preclude the petitioner to approach the appropriate forum in accordance with law. Our writ petition stands dismissed. Parties to act on the subject.
Kindly allow kindly note down one submission of mine. I have got no grievances against the order of the learned magistrate. Learned magistrate is continuously directing.
So therefore, if you have grievance against the magistrate,
court
is not going to pass.
This is
Court
the
is not going to pass any order.
26. That has to be taken up, and I am. These are the circumstances.
That is what I have recorded. That you have no grievance against the order.
It should be interfered with. Even if a complaint is lying there and the magistrate order is not being taken up.
Please call the next matter.
Much okay.
Item number 11.
Number 11, my lord, application. My lord, here the case is that, my lord, the petitioner is an old aged lady. He is a devotee of the Lord Krishna. He used to visit the Vrindavan. Now, my lord, the last occasion on 27th day of May, when she returned her home, she found some unknown person occupied her premises, and she has informed by her sons that they have breaking their locks and enter into the. When she asked their actions, they refused to hand it over their premises.
What is your complaint? What you are praying for?
Some unknown person occupied my premises forcibly. I went.
So what is the prescription of law in that case, Mr. Chatterjee?
What is the prescription
of law in that case? Even if trespassers are to be evicted by
Well,
due process of law,
some persons,
police authority will not
Well,
come forward for
Well,
evicting the persons who have
there
entered
is
into a premise
there is an
and residing there. It is in disguise of eviction
in
proceedings,
in
which
my
is required
absence,
to be
if few
to be
persons
moved
entered
before the
into my
civil court.
premises, it's a very, but I lost the complaint. My lord, kindly see, when the police initiated the FIR, now the police asked me to visit the police stations, my lord, and handed over this
So
document.
FIR has been registered.
FIR has been lost. My lord, kindly see. Now, my lord, there is one difficulty. My lord, kindly appreciate. There is a report, my lord. My lord, there is one difficulty. Now the police is police. The police has handed over the key to the local leaders. A local leader asked me and to get the order from the High Court, then they will hand it over the key to me.
That's why this writ court has to pass an order.
But the local leader,
Due to requirement of local leader.
what is the authority of why the police authority? What is the statement of the police? My lord, kindly
But you have submitted to
kindly see the statement.
Well, that's a report, my lord, indicating that FIR has been registered in an investigation is ongoing, my lord. কি দেখাচ্ছে বলো?
Kindly see the.
This is for the purpose of investigation.
পারপাস সাফ কিন্তু এটা দেখুন অন্য লোকের হাতে দিয়ে দিচ্ছে লোকাল লিডারের হাতে দিয়ে দিচ্ছে সেটা তো এখানে কিছু সেটা লিখবে না
whether any private respondents are represented.
But they are parties, my lord. But
How you have served?
I
When
have
you have
served, but kindly
find it out when you have served.
intimation delivered, but no such person in the address.
When you have served.
I have served it on 2nd July. 2nd July it was sent, and it was
When they received it.
it was not served.
Then
but kindly see the
you are not submitting saying this.
but no such
But the
person
private
reside-
respondents are
how,
not
how
served.
could they receive it? They are residing at my premises. That's why they have not received it.
Why not? You will send it to their present address.
My lord, how I am sending this petition in my own address.
Sure.
My lord,
Take it
kindly-
back. Take it back.
My lord, kindly do one thing, my lord. Direct the police
It
authority
is
so
submitted
that
by the learned advocate representing the petitioner that service upon the private respondents is not complete.
But আমি একটা নিয়ে নিই।
Stop. Hearing of this matter stands adjourned. State respondent, complete stop. State respondents are represented by learned advocate. Stop. Hearing of this matter stands adjourned. This the matter under the heading motion non-service in the monthly combined list of August 2026. Next paragraph. Learned advocate for the petitioner is directed to complete service upon non-appearing respondents by 10 days from date and file affidavit of service on the next day. Since you have made them party, you have to serve notice upon them.
But I have served, my lord. But kindly
Yes, yes.
my affidavit of service, my lord. Item number 12.
Don't file it.
Item number 13.
My lord,
Lordship, item number 13, I cannot do this matter without a report. Without a report, Lordship, of factual finding from the police.
I'm just adjourning the matter, not passing this. Adjourn till 28 July.
Grateful, Lordship.
Item number 14.
Lordship, I am appearing for the petitioner, Lordship. Affidavit service, Lordship. Fact of the case, Lordship.
What about service upon the private respondents?
Private respondents, one private respondent is already served.
Section 7 when they were served.
Between 6 and 7, 7 was served, Lordship. But
What about 6?
So far, the second 6 matter reached at the destination, but did not serve.
Then you have to complete service. Sorry. Why you have not? Why by filing the writ petition? Why you have stated that matter is to be moved on particular that is it was filed on 1st of July. এই কবে মুভ করবে এটা তো দেয়নি এখানে দিলে কি করে এটা দেখো এখানে লেখা নেই It was filed on 1st of July and matter was scheduled to be listed on 6th of July within 5 days. Why?
The service upon the respondent number 5 and 6
Issue.
was effected, Lordship.
Service upon all the respondents is not complete. However, state respondents are represented by learned advocate. Next paragraph, learned advocate for the petitioner is directed to serve notice upon non-appearing respondents by 7 days, by 10 days from date and file affidavit of service on the next date. Next paragraph, list the matter under the heading motion non-service in the monthly combined list of August 2026. Take 10 days more time, 15 days more time for completing service.
Lordship.
Item number 15.
Lordship, in this
Lord,
matter,
I am appearing for the petition in this matter.
Yes.
in this matter, Lanet AG, Mr. Rajiv Mondar will address the court.
Yes.
Lanet AG, Mr. Rajiv Mondar will address the court. Kindly make it short pass over. He's
Mr. Bandyopadhyay, prayer is made for accommodation on behalf of the state.
Lord, then in that case, yesterday also they were there. CBI was not there.
Yeah, I've just talked with him. He's on the way.
Okay,
Who is
then
handling for CBI? Mr. Bandyopadhyay, in that event, what is the urgency?
no, it can be taken up tomorrow also, no problem.
The problem is tomorrow your matter, there are other urgent matters are fixed. So let it
Has
be on next Monday because this court has difficulty on Thursday and Friday.
Very nice. Monday at the top, my lord.
Well, Monday, let it retain its position. It will be fair at the top, fairly at the top.
Man, no problem. No problem. If it is
No,
taken up, no problem.
It may be taken up today also. He is on the way, Lordship.
Other matters are there. I cannot complete my
matters are
list.
there, we have also.
Next Monday.
He's there.
Yes, Mr. Bandyopadhyay, I mean next Monday.
My
Oh,
lord.
Mr. Mojumdar has come. Mr. Mojumdar has come. Let me see.
My lord, what has happened, your lords, kindly come to page. I will be, whatever the prayer I have made, now I am changing my prayer. Some developments have been taking place.
Developments are there.
Some developments. Kindly come to page 5. Your lordships will find that 7 criminal cases I have given. Now, but 7 criminal cases I have already got the page.
But you have prayed for registration of FIR.
Just a minute. But that part is not required now. I am just kindly just bear
How
with
that
me.
is maintainable in view of the judgment?
I am coming. I am not asking for that. I am not asking for that now. I am just, please wait, my lord, kindly.
Yes.
What has happened, my lord? After that, my lord, I'm a ex-MLA and I have been made have been made as a president of the district of the All India Trinamool Congress. My lord, kindly come to paragraph 5. Now, this is what has happened, my lord. CBI officer attached to Nizam Palace, Kolkata. He has come, he has said that he is a CBI officer. And he said that he should meet with the some persons, etc., etc. Well, on the basis of this,
Just a minute. Paragraph. I am on paragraph 5. Just a minute. Yes, paragraph 5.
now on the basis of this, I have lodged a complaint before the police station. Now, I kindly allow me to use the supplementary affidavit. Some development of fact is there that on that basis, police has already lodged an FIR.
Very good. FIR has been registered.
Very good. Very good. Now, my lord, kindly take my supplementary affidavit. Another fact. Now, after that, my lord, kindly see, my lord, another person has come and asking for money, describing himself to the some person of the SP of the Hooghly Rural Police. They are asking for money. That is also a complaint has been lodged and that has also been registered as an FIR by the police. I want today to know how many cases are pending against me with the police and the
There is
CBI.
such prayer in the writ petition.
EFG.
Yes. I have made that.
Prayer?
E, F, and G.
But these are the cases, Mr. Bandyopadhyay, which were initiated based on the complaint lodged by the petitioner.
No, I am not on that.
Whether Hooghly River Bridge. Now, both are CBI.
No, one is CBI and another one. Both the case, one is CBI, another is Hooghly Rural Police Representative.
Hooghly Rural Police. Now, based
Superintendent.
concerning these two complaints, already complaints have been
Complaint
transformed
has been
into
addressed.
FIR.
Complaint has been addressed. Now, now,
Where is the case made out in the writ petition that that cases, criminal prosecutions or criminal proceedings are initiated against you?
yes, yes.
Where is the where
Yes.
is the case made out?
Criminal cases. I have said that when I filed the writ petition, that time the FIR was not lodged.
No, no. On the basis of your complaint, FIR was lodged.
Well, that is later. When I filed the writ
The
petition,
basis of your complaint, two FIRs are lodged. Now
Lodged.
you are submitting that what are the cases pending against you?
Whether any case pending against me,
To that
otherwise
extent,
another.
to that extent, have you made out a case in the writ petition?
Yes, yes, I have.
Where?
But kindly see first. First is paragraph 5, 6, 7. When these incidents had happened, kindly remember, my lord, before registration
What
of
are
the FIR, I have
the
filed
case
this
made out?
petition.
Where is the case made out relating to the the cases which are which were initiated against the petitioner?
No, I do not know whether is kindly appreciate this. Just kindly appreciate before registration of the FIR on the basis of my complaint, this writ petition was filed.
That I get you. And during pendency of the writ petition, FIR has been registered.
Right.
That is relating to your complaint.
Yes, right.
That is relating to your complaint.
Correct, Miller. Correct.
Yes.
Absolutely.
Now you are submitting that there are criminal prosecutions might be pending against you, may be pending against you.
Whether
what are those prosecutions? Now I can consider your prayer provided a case is made out in the writ petition that there are there might be there are possibilities of pendency of certain criminal prosecutions against the petitioner.
Because Miller, kindly see this earlier when I kindly come to Miller page kindly come to page 6. Kindly see page. Kindly come to page 5 first. Page 5C. Kindly come to Miller first. Serial number 4. Chinsura Police Station case number 180 of 2000 bail granted on 24.
Unknown individuals. Unknown individuals. Paragraph 13, Mr. Bandyopadhyay, in view of the repeated assertions made by the unknown individual.
I don't know them. I don't know them. Both the two complaints are related to unknown persons. They are describing a name to me. I have said to them.
So what is your apprehension that cases have been initiated by CBI?
But yes, of course I have. Because this gentleman has come and said that the CBI, you will be arrested.
Who is
and
representing
thereafter
CBI?
the CBI
Yes.
has, neither the police
What is
has
your
taken any
instruction?
step.
Whether the CBI has initiated any case against the petitioner?
That part we have to submit report in this regard. So far, this concerned annexure P2, page 29, it has been mentioned that one unknown person came as presented.
Very well, submit a report whether any criminal cases are proceedings are pending against the petitioner or not at the instance of the CBI.
That we will submit it. But only thing, Lordship, I am pointing out the PDA, the complaint made that one person
Yes,
came
yes,
to the Nizam Palace.
Matter is heard in presence of the learned advocates
1.5 years back from
representing the
Nizam Palace.
petitioner, state respondents, and Central Bureau of Investigation. Next paragraph, Mr. Kalyan Bandyopadhyay, learned senior advocate representing on virtual mode, submits that after filing of this writ petition, complaints which were lodged before the concerned police authority are transformed into FIRs. There are two FIRs.
Two FIRs.
Are transformed into FIRs. And it is submitted to that extent grievance of the petitioner is redressed. Next paragraph. However, it is further contended on next paragraph. However, it is further contended on behalf of the petitioners No, however it is common. However, apprehension is expressed on behalf of the petitioner that since claiming to be representative of CBI, persons met the petitioner at his residence, comma, there might be pendency of prosecutions, pendency of criminal proceedings against the petitioner initiated by the which are initiated by the CBI. Stop. Prayer is made on behalf of the petitioner for disclosure of particulars of criminal prosecutions pending against disclosure of particulars of criminal prosecutions, comma, if any, comma, pending against the petitioner stop. Next paragraph. Learned advocate representing CBI is directed to file a report disclosing whether any criminal prosecution is pending against the petitioner or not by filing a report by 10 days from date. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 30th July 2026.
But just 1 second, I just said, this is nothing.
Yes.
Police must, in this case, actually police's names are being used. Police and the CBI's names. For their maintaining goodwill, they should investigate it immediately.
Yes, let me see. Let a report be filed.
Well, deeply obliged to you. Deeply obliged.
Item number 16.
I have to put the petition.
May I file the matter of deputy service?
Yes.
The land of the petitioner has been properly demarcated, identified, and handed over position.
So nowadays, police is demarcating land.
No, by the land acquisition department. Well, what is the case? A mob of 30-40
No,
persons
nowadays police is demarcating
in
land.
presence of the police, so that law and order be maintained.
Approach the West Bengal Land Reforms Tenancy Tribunal.
No, well, that chapter is not here.
An authority.
Well, that I am not on that. Well,
That is not the authority to demarcate the land in question.
Well, demarcation is not.
Petition is dismissed with cost.
Well, demarcation is not required. Well, kindly appreciate what is my case.
Fishing in troubled waters.
Land.
Fishing in troubled
No,
waters.
land was initially requisitioned by the land acquisition authority. By virtue of the order of this honorable court, my lord, that has been released. Well, in the year 1995, the position.
What you are paying for?
Well, they have, my lord.
This authority will do what you are paying.
Well, they have, my lord, break open the padlock on the pretext that all the papers are forged. The order of this honorable court is forged. And, my lord, no demarcation, no identification has been made by the land acquisition authority. And they, my lord, now not allowing the, my lord, petitioner to, my lord, enter into my property. Lordship, can they have a look, my lord? Page 74. My lord, your lordship will come to know what is the actual state of, my lord, affairs. 74, my lord, kindly have a 72 is the order, my lord, of this honorable court. That has already been completed, my lord. This is
No, this one number 5 states support.
Copy down. So with regard to peaceful possession of the occupants, respondents number 5 should not disturb the possession of the petitioner. Now, any suit is pending?
No.
Nothing.
No.
Now, whether police authority will decide the interstate right of
no,
the
my lord, they have to.
for the land in question.
My lord,
If your possession is being disturbed at the instance of the private response, in that event, you have to approach the appropriate forum. What police authority will do?
No, my lord, they have to broke open the padlock. Kindly appreciate, my lord, kindly have a look, page 74. Lordship, kindly have a look to the page 74. They have, my lord, broke open the padlock.
Affidavit of service filed on behalf of the petitioner is taken on record in spite of service of notice. Respondent numbers 5 is not represented. However, state respondents are represented by learned advocate.
5 is represented. 5 is represented.
Mr. Chatterjee is representing 5.
Number
I
five,
am representing the state.
Oh, you are representing
My lord,
Mr. Five.
Yes.
So what is your submission?
This was
I thought Mr. Chatterjee's
Junior standing
representing the
counsel.
state.
yes, but that my lord, supporting them.
Yes.
My lord, here, my lord, this land was given by Bengal Shrachi. My lord, remembers those West Bengal Housing Board land. My lord, that was taken requisition. All these records are there in the petition itself. Requisition from him, my lord, given to Bengal Shrachi. They developed it. We are and land, my lord, association living there. Our sewage treatment plant is there. 3 sewage treatment plants, one after the other. Bengal Shrachi, my lord, right beside Obishik, those 3. So those lands, my lord, some interlopers come. The petitioner has sold it off. A remaining parcel was remaining. She sold off to KMC also. The remaining portion of land. Now someone else, my lord, someone else has filed is signing. Some Suninwal Haldar. We don't know whose authority is this in the name of the petitioner. Petitioner has, my lord, some impression that my lord, her signature is also not very well evident. So, my lord, that is there. So, they.
But the allegation is made that the police authority went there and broke open the padlock and
it's not their land
and recovered relevant documents.
No, nothing of that. My lord, it's absolutely, my lord, because it's not there. It's a sewage treatment plant. What documents will be there in sewage treatment plant, my lord? My lord, of the association, my sewage treatment, my lord, then, my lord, this was not serviced by the KMC, my lord, high drains. Long back, my lord, when this came up, 2002-3. So then every building had to come up with their own sewerage treatment. So this was, my lord, Bengal Shrachi with the West Bengal Housing Board. They developed this. Land was requisitioned by West Bengal government. Now they are saying we are the owners of the land. It was a government land acquisition process way back in 2002.
My lord, kindly have a look to the order of this honorable court, my lord, page 72. Lordship, kindly have a look once.
Page
72. My lord, what is the requisition has been, my lord, the de-requisition it is. Page 72. This is the order of this honorable court. And by virtue of this order or honorable court, my lord, the demarcation was made in presence of the police authorities. But this is my
full order is not annexed.
No, 52 requisition is there. Page 52, government's requisition the land.
Requisition the land.
My lord, no, my lord, that was de-requisition by virtue of this order of this honorable court. Now, my lord, kindly have a look to the order.
No, whether police authority will decide that who is
They
having
have
right over the land.
opened the padlock. My lord, now not entering into me. My lord, not allowing me to enter into my own property.
A sewage treatment plant.
My lord, there is no, my lord, lordship, kindly have a look, page 74.
Affidavit service filed on behalf of the petitioner is taken on record. Learned advocate representing the petitioner submits that petitioner submits that possession of the land in question is being obstructed by the respondent number 5, prompting the petitioner to access this court with the present writ petition, seeking direction upon the concerned police authorities, which would facilitate the petitioner to enjoy peaceful possession over the land in question. Next paragraph. Learned advocate, Mr. Chatterjee, learned advocate representing respondent number 5, and Mr. Das, learned additional government pleader representing state respondents have jointly opposed this writ petition. Since oppose this writ petition, and it is submitted that the issue involved in this writ petition relates to civil in nature. Stop. It is submitted on behalf of the respondent number 5 that land in question was requisitioned by the concerned state authority. Therefore, right as claimed by the petitioner over the land in question cannot survive. Next paragraph. Having considered the respective submissions made on behalf of the parties, it appears that dispute concerning on behalf of the parties, it is found that petitioner is aggrieved by the disturbance made by the private respondent in peaceful possession of the land in question. Stop. If possession of the petitioner over the land in question is disturbed, in that event, petitioner is required to approach the appropriate forum in accordance with the law. Police authority is not the appropriate authority to decide the right of the petitioner over the land use. Next paragraph. Hence, no relief can be granted to the hence no relief can be granted to the petitioner, and the writ petition stands dismissed. However, this order shall not preclude the petitioner to approach the parties to act on the server copy.
Nothing, my lord, remaining.
Item number 17.
Yes.
I am for the private respondent number 7 to 9.
My lord, in this matter, it has been filed for the overaction of the police, my lord.
Louder, please. Use microphone.
My lord, this petition has been filed for the overaction of the police, my lord. Overaction of the police, my lord. The private respondent number 7, 8, and 9, they have filed a case under 163 BNSS before the learned judicial magistrate, my lord, regarding with an intention to over a plot of land, to grab the plot of land. My lord, kindly see the order of the magistrate. It is in page number 16 of the writ petition, my lord.
The issue is entirely civil in nature. We are the recorded owner of the land for 70
No,
years.
that is a different issue.
70 years. I have the inquiry reports and all. I can show you.
I cannot understand the prayer couched in the writ petition.
My lord, the fact is this.
They have not mentioned the plot number
Nothing is
also.
mentioned. It's an omnibus prayer.
My lord, kindly see the
Plot
photograph.
number is also not
My lord,
mentioned
may
in
I
the
be
writ
allowed to
petition
submit, my
and
lord?
annex my record of right in the writ
Adequate
petition.
safety and security in what respect?
I have, my lord.
Adequate safety and security of the petitioner in what
My lord,
respect?
that is the fact is this. Kindly see the learned order of the magistrate, my lord, order of the learned magistrate, that peace and tranquility, they have the intention to grab the plot of land which is under dispute.
So you
And my
approach the
lord,
learned magistrate in that event.
my lord, what happened? No,
proceeding
no,
which is
I am
pending
not on
before
that, my lord. What happened? After the order of this magistrate, my lord, I have no grievance against the order of the magistrate, my lord. The fact is these two constables who are the respondent number 5 and 6, and under the instruction of respondent number 4, who is
trying to carry out the order of the magistrate.
my lord, is this
Yes,
the order of the
grateful.
Maintaining peace and
my
tranquility.
lord, is
Yes,
this the order of the
that is the
magistrate
thing.
to fence the entire area?
What will I do?
And
My
they have blocked
land.
my-
They are
they have no-
trying to grab my land. What will I do?
my
ma'am?
lord, that's
Lord,
a there's completely separate question. Whose land is this? And that case is pending on behalf on that.
That is
So
why
this
I am.
is not a proper forum to place the title dispute over here. My problem is, my lord, they have blocked my entire exit and entry.
No such incident happened, Milord.
This is my problem.
No such incident happened.
And
I can
have
show you
placed the
the
photographs, my
pictures, Milord. I will show the.
Stated in the writ petition
Yes, my lord.
that your exit and
Yes, my lord. Yes, I have stated in the representation, and unfortunately, when
They
I
have
went to the-
several ways.
when I went
ways,
to
Milord.
the
Kindly show.
allow her to make
exactly what is this? When I went to the police station, I waited there for till 11 p.m. for 2 days. They did not register my complaint. Then I have to send it through post, my lord. By speed post, I have sent.
Police did not register your complaint.
That is also a fact. And the two constables, the persons who are shown.
If police does not register your complaint in that event, you have to approach the jurisdictional magistrate.
My lord, that is
Exactly, Milord.
what happened, my lord. The persons who are shown in these photographs, my lord, they are the constables of those police station. And that's why,
Photographs will not do.
and what they have stated, my lord, that they are complying the order of the magistrate.
Adjudicate based on the photographs.
My lord.
What is the case made out in
My
it?
case is that the police overacted on the basis of the order of the learned judicial magistrate. They have stated that
Then
we
you
are
have to bring
complying
it to the notice of the learned judicial magistrate.
My lord.
Why you are before this court?
The remedy.
My lord, as your lordship may direct that, then I will do it that only. But the main problem is, my lord, since the police acted on the basis of the order of the magistrate and police blocked my exit and entry, my lord. So that may be removed. Maybe I may
File
be
your affidavit of service.
my lord.
Affidavit of service filed on behalf of the petitioner is
I may be allowed to remove that fence, my lord. Only my humble prayer.
that there is overt action on the part of the concerned police authority in carrying out the order of the magistrate. At the same time, it is also submitted that ingress and egress of the petitioner is obstructed by the private respondent.
By the police itself, my lord.
Is obstructed. Private respondent is greater. Next paragraph. Learned advocate representing respondent number, you are representing
7 to 9, my lord.
representing respondent numbers 7 to 9 opposes this petition and disputes submission. Respondent number 7 to 9 disputes the submission made on behalf of the petitioner, and it is submitted and it is further submitted that the issue involved in this petition is civil in nature. Stop. You have the right over the land in question.
Yes, my lord.
No, my lord.
Yes.
That is under dispute, and so
No, my
cases
lord,
are
they have
pending on
annexed.
that.
They have annexed my record of right, my lord.
Not annexed
I
any
am
record.
recording his submission.
My lord, my lord.
I
I have
am not deciding the right of the parties over the land. It is further submitted that respondents number 7 to 9.
7 to 9.
Respondent number 7 to 9
যেটা
have
সার্ভিস
right
হয়েছে
to the
সেটাই
land
আছে
in question.
দেখিয়ে দিচ্ছি আমি দেখিয়ে দিচ্ছি
Next paragraph. If state respondents are represented by learned advocate. Next paragraph. In the event there is overt action on the part of the police authorities pursuant to the order passed by the magistrate, in that event
এখানে কোনো annexed নাম্বার নেই ভুল করে দিয়ে দিয়েছে
taking up required to approach the magistrate.
আমার কানেকশন লিস্ট অফ কানেকশনটা তো
এখানেই তো আমি বলছি
However, next paragraph. However, from the respective submissions made on behalf of the petitioner and respondent number 7 to 9, petitioner and respondent number 7 to 9, it transpires that the dispute is concerning land in question as well as ingress and egress of the petition. Stop. Police authority is not the appropriate authority to decide the right of the parties over the land in question, and parties are required to approach civil court in pursuit of remedy.
Grateful.
Next one. Hence, present writ petition is not interfered with, and same stands dismissed. However, this order shall not preclude the petitioner to approach the appropriate forum in pursuit of
My lord, one subsequent civil case is already pending, my lord. Can that be?
Next matter.
Grateful.
Item number 18.
Yes, yes.
My lord, page number 42, my lord. I made a representation before the police authority.
Use microphone.
My lord, page number 42, my lord.
Point it to you.
My lord. My lord. My lord, page number 44, my lord. My lord, private respondent, my lord, I am residing my house.
Private respondents, who is appearing for the private respondents?
My lord, I have served.
How you have served?
My lord.
ওটা ওনাকে দিন. Find it out when the private respondents were
They
served.
have all received, my lord. I have checked out.
8, 9, and 10.
Yes, my lord. All are received. My lord. All are delivered on so 6th July 2026. All are delivered. And my lord,
sent or delivered?
Delivered. No, sent before 2 days ago, and my lord, 6th July,
yes,
they have
yes,
received. My lord,
yes.
my lord, page number 44, my lord. I am residing on this my house. Beside my house, my lord, I have a vacant land, joint property, and my lord, private respondent forcefully, my lord, throwing the garbage, dumping this garbage, all these things, my lord, and the unhygienic of this area, and my lord, they threat, my lord, this is the my complaint, my
What
lord.
you have prayed for?
My lord, my prayer is, my lord, only basis of this complaint, the police take steps, my lord, pay 13, page number 13.
Petition.
So your prayer is lodging of FIR.
My lord.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate representing the petitioner submits inaction on the part of the police authorities in registering FIR prompts the petitioner to approach this court seeking direction upon the concerned police authorities. Next paragraph. Learned advocate representing the state respondents has submitted that there is an alternative remedy available under section 175 3 BNSS 2023 by approaching jurisdiction.
Apart from that also, Lordship, the allegations are all of non-cognizable nature. So it's actually a Alternative remedy should be a complaint under 200.
It is
Not-
also submitted that the offense reported is non-cognizable in nature. Next paragraph. If petitioner is agreed by inaction on the part of the police authorities in registering FIR, in that event petitioner is required to approach jurisdiction magistrate under section 175(3) BNSS 2020. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2007-6 SSC 171, Aliu Kadamsi and others versus Union of India. Next paragraph. In view of availability of alternative remedy, writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach the jurisdiction magistrate to approach jurisdiction magistrate in pursuit of remedy.
Keep sub vigil of this local malad.
Yes, parties to act on the server copy.
Sub vigil of this local malad.
No.
Garbage throwing also police has to do.
Item number 19.
No consolation prize. Yes.
That I appear for the petitioner. What happened? The petitioner is a tea company in North Bengal.
Yes.
North
Bengal.
Uttar Dinajpur. No, that is Uttar Dinajpur, principal bench only. Uttar Dinajpur.
Just a minute.
Yes. Islampur.
What about the private respondents?
The private respondents, we have sent it on 3rd of July.
Whether services
No, it's still it's still showing in transit.
2nd July it was filed. In Uttar Dinajpur it will take some time. And it is in the presentation form it is stated that matter is to be moved on 9th of July.
Yes, now it is
take 7 or 10 days more time.
Problem, yes, that is there. The problem is otherwise. We are completely
without hearing the private respondents, court cannot take up the without
that I understand, but I understand. The problem is, we have our office there. This is the company is approaching before your lordship. Problem is the big mob led by this the private respondents. They have barged in the office, completely vandalized. Now, our business is totally closed where we cannot enter.
Private respondents are to be served.
Definitely yes. Definitely yes, we have sent it on 3rd itself,
Issue.
the report
July so and so.
My lord, may I file the report?
Civil dispute Civil dispute.
My lord, may I file the report?
Not today. Let the service be effected. Service of notice upon all the respondents is not complete. However, state respondents are represented. Next paragraph, Mr. Bhattacharya, learned advocate representing the petitioner submits
126.
That office of the petitioner company was vandalized at the instance of the private respondents.
And a mob.
Stop. Next paragraph. Learned advocate for the petitioner is directed to complete service of notice by 10 days from date and file affidavit of service on the next date. Service of learned advocate for the petitioner is directed to serve notice upon non-appearing respondents. Or you have already said.
Sent. Yes.
Is directed to complete service of notice upon the respondents by 10 days from date and file affidavit of service on the next date. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 30th July 2026. Next.
Item number 20.
Lordship, I appear on behalf of the petitioner. This is the affidavit of service.
Yes.
Lordship, being aggrieved by the banking scam as well as the banking scam by accused number 10 and the extortion by accused number 9.
What you are praying?
I'm praying for impartial investigation as well as
whether the FIR has been registered.
No, Lordship, the FIR has not been registered yet, but The fact of the case is, Lordship, very briefly, I'm narrating.
No, it's not required. What you are praying for, tell me whether you are praying for registration of FIR.
I'm praying for the registration of FIR as well as
How that is maintainable in view of availability of alternative remedy.
Lordship, they have
You
not.
have to approach the jurisdiction magistrate unless and until it is extremely urgent matter and the life and liberty of the petitioner is at stake.
Lordship, I am being scammed for about 2.5 lakhs.
Please take it back. It's not required. Learned advocate representing the petitioner submits issue involved in this petition relates to a financial scam requiring
Lordship, if you may permit, may I place one
requiring
judgment of this
initiation
coordinate
criminal
bench?
prosecution by registering FIR. Stop. Opore affidavit service টা করে দাও. Stop. State respondents are represented by learned advocate. And it is submitted that there is an alternative remedy available under section 175(3) BNSS 2023 by approaching jurisdiction magistrate. Next slide. Since it is contended on behalf of the petitioner that there is inaction on the part of the police authorities in registering FIR, petitioner needs to approach the jurisdiction magistrate.
Lordship, I have filed the demand for justice
BNSS 2023
before the appropriate.
Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2007, Volume 6, SCC 171, Aliu Padamsi and others versus Union of India and others. Stop. In view of availability of alternative remedy, present writ petition is not entertained and same stand dismissed. This order shall not preclude the petitioner to approach the jurisdictional magistrate in pursuit of remedy. Parties to act on the server copy. Next.
Item number 21.
Done. At the time of call, no one appears for the petitioners, and no accommodation is paid for. Writ petition stands dismissed for default. Parties to act on the server copy.
Item number 22.
In this matter, I have put a statement.
Yes.
I'm appearing for the petitioner,
Yes.
my lord. My lord, my contention is that there was a purported lease agreement notarized where petitioner was a de facto complainant connection with Nodakali PS 134.
So you are praying for fair, impartial, and
Yes.
effective investigation.
For
Whether the
forensic
FIR
examination.
is registered.
Yes, my lord.
FIR is registered.
Registered, lodged under section 336, subclause 3, 318(4), 61(3),
So
152.
in that event, if the police authorities are required to take steps in connection with the investigation, then you have to approach the jurisdictional magistrate.
My lord, I have already 175 clause 3. I have already done, initiated, and there was no meaningful progress in the investigation. And it is my Article 21 is inflicted fundamental right. And my lord, not only that, this signature.
How the investigation by the police authorities can be brought under the fold of the fundamental.
My lord,
Under Article 20.
My lord, there is a forensic
If you
examination.
are agreed by the order of the jurisdictional magistrate in that event, you have to take steps.
My lord, I have taken steps for.
There is a judgment, recent judgment of the Supreme Court, which specifically dealt with the issue, and it is submitted that it is observed that if a person has a grievance, that is FIR has not been registered by the police, or having been registered, proper investigation, as it is your case, proper investigation is not being conducted, then the remedy does not ordinarily lie in invoking writ jurisdiction in the first instance, but in seeking recourse to the statutory framework, unless, of course, the urgency of the circumstances warrant other.
My lord, urgency is that already 175 PNS already has been initiated.
What are the
before
sections?
Alipur.
What are the
And
sections?
Forgery to purpose of cheating.
Yes.
Under section 330.
So therefore, your personal liberty is not at stake.
18(4).
Your personal
My lord,
liberty is not at stake.
My lord, regarding
My lord,
these
I have got
agreements.
the private response.
It's not required. You did not.
My
You
lord,
did not raise your voice here. Why you are wasting court's time?
Civil petition are pending.
Why you are
my
wasting
lord,
court's time?
purported agreement which has been leased with fabricated and forged signature, my lord.
Civil litigation is pending.
Civil litigation, where it is pending.
Before filing this FIR, my lord.
Where
It
is
is Nodakali PS case number 134 dated 14 March 2025.
Yes, my lord.
Affidavit,
My lord,
file your
kindly-
affidavit of service.
Kindly see my, yes,
File your
I'm
affidavit of
filing
service.
affidavit of service.
Affidavit of service filed on behalf of the petitioner is
Yes,
taken on record. Learned advocate representing the petitioner expresses
My lord,
dissatisfaction
kindly consider my prayer, my lord.
investigating criminal prosecution being Nodakali PS case number 134 dated 14 March 2025. Stop.
Report me, report me.
It is submitted,
Madam,
it is,
report
it is submitted, it is further submitted on behalf of the petitioner that concerned police authorities are required to investigate with more circumspection and alacrity. Next paragraph, state respondents and respondent number.
Respondent number 6, private respondent number 6.
Respondent number 6 are represented by learned advocates. Stop. Next paragraph. Having considered the case made out on behalf of the petitioner, it appears that petitioner is not satisfied with the steps taken by the concerned police authorities in the aforesaid criminal prosecution in course of investigation, which requires the petitioner to approach jurisdiction magistrate within the statutory framework as it was decided by the Honorable Supreme Court in Tujal Bishas Attavar and another versus State of Maharashtra and others. Reported in 2026 SCC Online SC 79. Stop. Next paragraph. Hence, writ petition is not interfered with, the same stands dismissed. However, this order shall not preclude the petitioner to approach the jurisdiction magistrate in pursuit of remedy.
Once indulgence, my lord,
Grateful, your lordship.
direct them to supply me with the reports.
Grateful, your lordship.
Reports.
No, I have not considered the report.
Grateful, your lordship.
If I would have considered the report, then I
Great.
would direct that the report to be supplied to you. Yes.
Item number 23.
23, I beg to appear for the petitioner. This is the affidavit of service.
No, private respondent.
No, I'm only beseeching.
You are appearing for the petitioner.
I'm appearing
Yes.
for the. This is the affidavit of service. I'm only beseeching your lordship to seize the original document from the respondent number 5.
In connection with the criminal prosecution.
In connection with the criminal, FIR has been registered.
So you approach the jurisdiction magistrate.
Grateful to your lordship.
My lord.
Previously, I used to pass these orders.
Grateful
But
to your lordship. I will.
The judgment reported in 2020.
I have heard in several cases that your
Yes.
lordship is kindly grateful to your lordship.
But I am for the respondent number 5. It is already
Affidavit of service filed on behalf of the petitioner is taken on record.
Lordship, charge sheet has been filed.
filed there.
Charge sheet has already been filed.
It's been filed.
Cognizance is taken.
Cognizance.
Petitioner granted
Actually,
granted bail.
That
Anticipated
instruction
bail.
I do not have at the moment.
It's Kotwali PS case number 1426
26 of
2025.
25.
But kindly see only one.
Please take your seat.
My lord, my
If it is required, I will hear
My
you.
lord.
Page 2, Lordships, penultimate paragraph.
If any order is passed affecting your right, then I will hear you.
They have already filed an
Again, you are. Yes, charge sheet number 287 of 2026 dated 31st March 2026. This is the charge sheet file.
Yes, Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate representing the petitioner submits that certain articles are required to be seized in connection with criminal prosecution being Kotwali Police Station case number 1426 of 2025 dated 25th December 2025. Stop. Prayer is made in this writ petition for issuance of a direction, for issuance of mandamus directing the concerned police authorities to take steps. Next paragraph, state respondents and respondent number. You are representing which respondent?
Respondent number 5, my lord.
5 are represented by learned advocates. Stop. Next paragraph, Mr. Das, learned additional government leader representing the state respondents, has filed a communication dated 13 July 2026 of Inspector in Charge, Kotwali Police Station, and same is taken on record. Stop. Copy of the said communication dated 13 July 2026 are made over to the learned advocates representing the petitioner and respondent number
5.
5. Stop. Next paragraph. It is disclosed in the communication dated 13 July 2026 that on completing investigation in aforesaid criminal prosecution, charge sheet was filed being charge sheet being number 287 of 2026 dated 13th March 2026 is already filed. Next paragraph. In view of filing of charge sheet, no further order need be passed on this writ petition, and the same stands disposed of. Parties to act on the server copy. However, filing of charge sheet shall not preclude the petitioner to approach the jurisdiction magistrate if occasion so arises.
Grateful, Your Lordship.
Grateful, Lordship.
Next.
Item number 24. Stated, Your Lordship.
Yes.
My lord, I am for the state led by learned JP, my lord.
Pursuant to Lordship's direction, in a writ petition, my lord, an FIR has been registered, my lord, by Iqbalpur Women Police Station.
In what?
Iqbalpur Women Police Station. My lord,
What guns?
What guns? I stand for what guns police station. But thereafter, what happened? The case was registered under section 85, 74, G, and 89 of the BNS. What happened, my lord? Section 89 of the BNS
responding to 490.
No, P13 miscarriage.
No, 85.
85.
85 is subject, yes. 498A,
yes.
74, my lord, assault or use of criminal.
Yes. Now, what you are praying for?
I am praying for my lord comes to the first, if my lord comes to the page number, my lord, 20. Page number 20 of the application, my lord. 22. The first one.
No, in view of the law decided when the investigation is going on,
no, my
writ court will not interfere with.
No, my lord will kindly see this 22, page 20.
Because you have prayed for calling for records relating to Watganj police station case number and upon examination, quashed and set aside.
My lord will kindly see page 22 for a moment. Page 22 for a moment.
You are the accused.
I am the accused. I am residing at Mumbai. My lord, what happened? My brother-in-law's wife has registered this case. My lord will kindly see to page 22. Does the charge of causing miscarriage stands in our favor? My lord will kindly see page 22 for a moment. Page 22. Who has signed? Tansia, self, Rehaul Islam, father.
Court will not enter into this issue at this stage.
But what happened?
Because things are hazy, as it was decided in Niharika infrastructure by the Honorable Supreme Court. At this stage, court is not going into the veracity of the allegations. Let the investigation be carried out and the report be filed before the authority.
But what happened, my lord? Only
it's a special provision.
No, I understand.
Now, this provision should not be exercised, or the power of the writ court under Article 226 of the Constitution of India should not be exercised in routine manner.
My lord, only on the basis of this document, I have been debarred, my lord, to avail the law under 35(3). Because to stop 35(3), which is 41A, my lord, this section has been.
Sorry, Mr. Mukherjee.
No, my lord, I tell you, lordship, one thing, my lord.
Here,
89 has been
prosecution has been initiated at 89. I am bound by the observations made by the Supreme Court in paragraph
I bow down to a lordship.
33.60.
Only for 89, my lord. Only for 89.
My lord, I have been debarred to avail 35(3), which is 41A, because only to make the punishment more than 7 years.
If you apprehend that you are going to be arrested, take anticipatory bail. Yes. What are the sections stated in the writ petition? Which paragraph?
Section 8.
Paragraph 6, page 4. Page 4, your lordship.
Section 85, 74.
85, 74, 316 and 89.
360.
Only for this 89, my lord, I am debarred to take the advantage of 35(3). I am residing at Mumbai.
I will not enter into this issue at this stage. Affidavit of service, have you filed? Affidavit of service, file your affidavit of service, Mr. Mukherjee.
Yes. Thou.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Mr. Rana Mukherjee, learned advocate representing the petitioner, submits that by instituting this writ petition, inter alia, prayer is made for issuing mandamus, thereby directing the concerned respondent authorities to coerce criminal prosecution, being Wadganj Women Police Station case number 4 of 2026, dated 6 June 2026, registered under section 85, sections 85/316(2)/89/35 of BNS 2023. Stop. It is submitted fastening of section 89 prevents the petitioner from getting the benefit under section 35(3) of BNSS 2023. Next paragraph. State respondents are represented. You are for the
Private respondent.
respondent number 4. State respondents and respondent number 4 are represented by learned advocates. Stop. As it is found from the submissions made on behalf of the parties that based on the complaint lodged, a criminal prosecution has been initiated. Aforesaid criminal prosecution is initiated by registering FIR on 6 June 2026, and investigation is at the nascent stage. Therefore, court is not inclined to interfere with the investigation which is being carried out by the concerned police authorities. Moreover, prayer is made for quashing of the criminal prosecution, which is not found to be tenable in view of the observations made by the Honorable Supreme Court in the judgment in paragraph 33.16 of the judgment reported in 2021-19 SCC 401 within bracket Niharika Infrastructure Private Limited versus State of Maharashtra and others. 33.16 টা এখানে কোট করে দেবে পুরো ছবি তুলে নিয়ে যাবে কোট করে দেবে স্টপ নেক্সট প্যারাগ্রাফ Niharika Infrastructure Private it is right that High Court, while exercising jurisdiction under Article 226 of the Constitution of India, ought to exercise its power of quashing criminal prosecution with circumspection and sparingly, not in routine manner. Stop. When an FIR has been registered and a criminal prosecution and an investigation is continuing, at this stage, court finds it not apt to make any observation with regard to veracity of the allegations of commission of offense. Stop. Hence, court is not inclined to interfere with this writ petition and same stands dismissed. However, this order shall not preclude the petitioner to approach the appropriate forum for seeking pre-arrest bail.
Grateful. The same order in the next matter also.
Just
only 89, I cannot take the advantage in respect of the petitioners, my lord.
I understand, but
no, my lord, in my lord's order, my lord, section 89 has been invoked against us, and
we have recorded.
Yes, I have seen.
Recorded.
I've heard. That is what I am telling you, lordship.
Yes. Next matter.
Item number 25.
Same matter, same prosecution.
No, item number yes.
Same criminal prosecution.
Yes. The previous
so
one
why
is
two writ petitions, Mr. Mukherjee?
But this is the brother-in-law, and the earlier one is the sister-in-law.
Where you have stated that paragraph 8, that the particulars of the proceeding. Yes, paragraph 3. Yes, 4 Women Watganj Women Police Station case number 4 of 2026. Same order put in. Same.
My lord, subject to my lord's leave, my lord, may I file one report, my lord?
I have not considered it. I am only on the point of the considering the case made out on behalf of the petitioner. At this stage, court is not interfering.
Yes, the investigation is on progress, ma'am. Great.
এই তুমি তো এটা বুঝতে পারবে না এইখানটা তুমি নিয়ে নাও ছবি তুলে নিয়ে এই অবধি দিয়ে আমায় দিয়ে দাও এটা লাগে
I'm grateful.
Yes, grateful.
Item number 26.
My lord, I am for the statement. This is the affidavit of service. My lord, 2 private respondent is there. I have served, my lord, they received. My lord, kindly see. My lord, kindly see, my lord, page 17. My lord,
What you are praying for?
Not praying for, my lord.
That has become very relevant question in view of the recent judgment of the Supreme Court. What you are praying for?
My lord, in spite of lodging the FIR, my lord, kindly, my lord, protect me from the private respondent.
FIR is lodged.
Yes, my lord.
Then what remains? Let the
they are,
investigation
my lord,
be carried
threatening me, my lord.
Let the investigation be carried on.
Yes, my lord. Kindly, my lord, direct the police authority to, my lord, the fresh and fair investigation. Fair and impartial investigation, my lord.
No, you have prayed that why respondent number 3 should not initiate appropriate steps to protect the petitioner and did not arrest the respondent number 5 and 9. Approach the jurisdiction magistrate.
Kindly protect me from the private respondent. They are the male culprit, my lord. My lord, I have.
Where is the criminal prosecution? Particulars of criminal prosecution. Where is the FIR particulars?
Page 17. My lord, I have already informed to the SP. My lord, page 28 regarding this issue. I am being a lady, my lord. I am seeking, my lord.
Have you served notice upon the private respondent?
Yes, my lord, I have served.
When? Find it out.
Okay, but 2nd July.
It was sent.
Yes.
When received?
Received, my lord. 3rd July. So, all the respondents received, my lord, 3rd July.
What is the complaint? What is the complaint?
My lord, sorry.
What are the allegations?
My lord, allegation, my lord, they, my lord, kindly see, my lord, the FIR, my lord, 307 is there.
What are the allegations?
But allegation is that, my lord,
since I have seen from the FIR.
Allegation is that, my lord, my husband used to, my lord, work in the, my lord, kindly.
Since petitioner is a lady and there are the sections that 126, 115, that's why I'm asking you. What are the allegations?
The private respondent are, my lord, the restrain the
You are not
pathway.
aware of the allegations. You are moving a petition.
They are,
before
my
this
lord, assaulted my husband. That is why I am logic.
So your husband was assaulted.
Yes.
So why husband has not come up?
Because my lord, kindly see the, my lord, the picture of the my husband. My lord, they, my lord, very, my lord, serious injury is there. That is why, my lord, I have lodged complaint.
When this incident of physical assault took place?
Took place, my lord, on, my lord, 4th May 2026 at 8 p.m.
Now he has recovered. Husband has recovered.
Yes, my lord.
So why he has not filed the petition on 2nd of July?
My lord, because, my lord, the, my lord, the wife of the, my lord, that is why, my lord, he is, my lord, came before your lords. My lord, my husband was injured. That is why, my lord, I have lodged a complaint.
Issue. Huh? Oh, just file your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Based on the complaint lodged by the petitioner. No, who lodged the complaint? Petitioner or her husband?
My lord, the petitioner.
Based on the complaint lodged by the petitioner, alleging that her husband was severely beaten on 4th May.
Yes, my lord.
Fourth May severely beaten up. A criminal, an FIR was registered, being which police station?
My lord, Horinghata police.
Horinghata police station. Case number 156/2026 dated 12th May 2026. But after registering FIR according to the petitioner, necessary steps are not being taken by the concerned police authorities by providing protection to the petitioner and her husband, as well as arresting accused persons. Next fact. State respondents are represented by learned advocate. Stop. Since it was alleged that husband of the petitioner was severely beaten up, and considering the complaint lodged in this regard, a criminal prosecution was aforesaid criminal prosecution was initiated, concerned police authorities are directed to take the prosecution to its logical conclusion at an early date by filing a charge sheet. Stop. However, if petitioner has grievance with regard to the steps taken by the concerned police authorities in connection with the aforesaid criminal prosecution, leave is granted to the petitioner to approach the jurisdictional magistrate under section 156(3) BNSS, under section 175(3) BNSS 2023. Next paragraph. Concerned police authorities are also directed to provide protection to the petitioner and her husband if occasion so arises. Stop. Read petition stands disposed of, parties to act on the subsequent. Grateful. এটা নিয়ে নিয়েছো তুমি? Call the list.
Item number 27.
May it be please, your lordship, I am virtually connected. This is my affidavit
What
of
about the
service.
private respondents? How private respondents?
No private.
When served?
No, there is no private respondent. Only state respondents are there.
All are petitioners.
Yes, yes.
30
But
petitioners.
what happened? 30 petitioners before your lordship. What
Yes.
happened after the state election? They have been subject to the post-poll violence, and they are still now they are out of their residence. These 30 petitioners are required to be reinstated in their residence, and for that reason, we are praying for an appropriate direction. We have made the representation to the police authority and the superior authorities, but no action has yet been taken. Our honorable
They are residents under the same police station.
They are residents under the same police station.
Where you have stated.
All of the cost title will say that they are the residents of the Fulbagan police station. All of Fulbagan police station.
No, there is one Kakurgachi PS.
No, Kakurgachi, there is no PS, my lord.
PS 27,
27 Narkotanga,
under the
Narkotanga main road.
Kakurgachi police station.
The PS Fulbagan 27. 27 is PS Fulbagan.
29 PS is not mentioned, lordship.
All are Fulbagan police station. Narkeldanga main road is under police station Fulbagan. All are Fulbagan police station. My lord, there is an order of our division bench. There is a Mr. Shishanda Bandopadhyay's case that I have referred in the page number 73.
Yes. Now, what prayer you have made?
Well, my prayer is at page number 16 onwards.
What you are praying for?
I am praying for the police will give our protection so that we can peacefully live in our house. Nothing more. Restoration of the position.
The petitioners are staying where at present?
Prisoner stayed either in the relative's house.
Where?
In different areas, the relative's house. They are residing.
Not staying at their residences.
No. After filing this petition, I came to know just right now the petitioner number 4 has been brutally assaulted and he is hospitalized. His left leg has been broken and he is undergoing surgery.
What about the court fees?
The court fees I will pay.
No, there are 30 petitioners. You have deposited court fees of one petitioner.
Well, today itself I will deposit within 15 minutes.
First put in court fees. It appears from the.
Can you make it pass over?
There are 30 petitioners in this writ petition, but court fee in respect of one petitioner has been court fee in respect of one petitioner was deposited at the time of filing of the writ petition. Next paragraph, blind advocate representing the petitioners prays for accommodation to put in deficit court fees. Let deficit court fees be put in respect of 29 other petitioners by 7 days from date on compliance of formalities. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 30th July 2026. Affidavit service নিয়ে নিতে বলো।
Item number 28.
28, my lord, I appear for the petitioner, my lord.
I am for the state respondent.
My lord, dispute over a ancestral landed property. There is a civil suit pending. My lord, this has started since 2021. If your lordship may kindly come to page 121.
Peaceful possession you have prayed.
My lord, kindly comes to page 121. instituted a proceeding under 147. There was a report filed by the concerned IC that there is every possibility of breach of tranquility and peace in the locality.
That is for maintaining peace.
My lord, there is an order of the civil court also where the learned civil court has directed us to maintain status quo.
So if if that is not followed, then
Order
you are
39
required
Rule 2A, my lord, 151
to,
is there.
required to take steps under order
But
39
they are,
to
they are repeatedly encroaching into our land. My lord, they are repeatedly encroaching into our land, disturbing our possession. Lordship, may kindly direct the police to maintain a strict vigil. That's all, my lord.
No, I will not direct.
My lord, they are
Sorry.
violating the order of this learned
That is
civil.
what the litigants are taking wrong path because of this direction which I was passing.
My lord, this has happened earlier also.
Where is the order of the order passed on order 39 Rule 1 and 2?
My lord, page 133, the civil court's order.
Suit at whose instance?
At the instance of the private respondent.
You are the defendant.
Yes. And I'm in possession, my lord.
And you are saying that that order is violated.
My lord, they were directed to maintain status quo. Well, I am in possession. They're encroaching, they're trespassing, they're cutting down trees and disturbing our possession, my lord. That's all, my lord. Lordship, may kindly direct the police authorities to maintain a strict vigil. We'll stay out of any.
There is no encroachment on our side, as he is alleging.
Private respondent. Affidavit service দিয়ে দিয়েছো?
Both of you are representing state.
No. Is for private responding 8 and 9.
What about the present status of the suit?
It's pending.
It is pending and absolute injunction is there and status quo is being maintained by both the parties.
So why you are violating the status quo?
No, violation there is as such there is no violation as he has stated in the petition.
My lord, I've intimated the concerned authority lastly on 12th
Affidavit
of
of
June.
service filed on behalf of the petitioner is taken on record.
Next one.
Learned advocate representing the petitioner submits that in spite of an order of civil court dated 6 July 2023,
এটা কি? এটা সেদিনকে আইটেম নাম্বার 4 যেটা ছিল তো যেটা পারিয়া দিয়ে করলো ওটার মধ্যে যদি দেখি লাস্টে দেয় স্ট্রিক্ট ভিজিল।
in connection with a suit, in connection with the title suit you have filed.
So it is a partition suit.
In connection with partition suit, directing the parties to maintain status quo regarding the suit property. Private respondents are violating
item 12 এর affidavit of service এর envelope
or respondent numbers 8 and 9 are violating said ad interim function. Prayer is made in this writ petition for issuance of mandamus directing the concerned police authorities to take steps for preserving right of the petitioners
to petition
over the property, over the suit property. And compliance of the said order dated 6 July 2023. Next paragraph, state respondents and respondent numbers
8 and 9.
8 and 9 are represented by learned advocates. Next paragraph. It is submitted by the learned advocate representing respondent number 8 and 9 that partition suit was instituted by them and same is still pending. In addition thereto, it is also submitted that In addition thereto, it is also submitted. In addition thereto, submission made on behalf of the petitioner to the extent of violating ad interim order dated 6 July 2023 is also disputed. Next paragraph. If ad interim order dated 6 July 2023 still subsists and petitioners find that same is not being complied with, in that event, petitioners are required to approach civil court in pursuit of it. Stop. Police authority is not the appropriate authority to decide the right of the parties over the suit property. Next paragraph. Hence, court is not inclined to interfere with the writ petition and same stands dismissed. But urgent Xerox certificate copy.
But can you direct the police authority to maintain a strict?
No, Mr. Sen. No.
Obliged.
Item number 29.
My lord, I am for the petitioner. My lord, this is a case, my lord.
I am for the private respondent number 4 and 5, my lord.
This is a case, my lord. The petitioner.
I respondent 4 and 5 you are representing.
Yes, my lord. This is the affidavit service, my lord. My lord, this is a case. The petitioner has lodged an FIR against the private respondent. Happens to be the
petitioner lodged FIR.
Yes, my lord. My lord, against the private respondent number 4 and 5. Privite respondent number 4 is the
Whether
husband.
FIR has been drawn up.
Yes, my lord. The subsequent to the registration of the FIR, my lord. Kindly see, my lord, it is in page number 17, formal FIR, and 18 is the written complaint.
When FIR was registered?
6th of June, my lord. And thereafter, since thereafter, my lord, the investigating agencies are not taking any steps. My statement has not been recorded. I have not been called for.
Learned affidavit service filed on behalf of the petitioner is not required. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate representing the petitioner submits that after registering FIR based on the complaint lodged by the petitioner, necessary steps are not being taken by the concerned police authorities to take the investigation to its logical conclusion. Next paragraph. If petitioner is dissatisfied with the inaction on the part of the concerned police authorities, in that event, petitioner is required to on the part of the concerned police authorities in investigating the aforesaid criminal prosecution or in investigating the aforesaid case. In that event, petitioner is required to approach the jurisdictional magistrate within the statutory framework as decided by the Honorable Supreme Court in Sujal Vishwas Attavar and another versus State of Maharashtra and others, reported in 2026 SCC Online SC 798. Next paragraph. Hence, present writ petition is not interfered with and same stands dismissed. However, this order shall not preclude the petitioner to approach the jurisdiction magistrate in pursuit of remedy. Parties to act on the sovereign. Next.
Item number 30.
Madam, for the petitioner.
Yes.
Madam,
Lord, I am for the private respondents.
Madam, for the statement. Madam, the petitioner is a 72-year-old lady. Her son and daughter-in-law. Lordship, she has been assaulted, beaten up, thrown out of her shop room. They are even trying to throw her out of her house. Earlier also, Lordship, complaint lodged in the year 2024.
Yes, daughter.
Thereafter, in 2026, page 37 is the formal FIR of the
Page
incident.
37.
37, Lordship. Is the FIR of the incident.
Page 35 is the FIR.
That is the previous FIR, Lordship. The 2024 also, the same incident happened. That is the time I had lodged an FIR. My son and daughter-in-law, son was arrested also. And thereafter, my lord, another incident took place on 22nd May. Page 37 is the formal FIR.
Yes, FIR has been lodged.
But Lordship, thereafter the assault and it's continuing. No steps have been taken by the authorities.
Now, after lodging a FIR, if the authorities are not taking steps, then you have to approach the jurisdictional magistrate.
Lordship,
What
if,
this court will do.
old lady, if some protection, police protection, or if the authorities take some steps, she's been thrown out of the shop room. They are trying shop.
So dispute is concerning shop, not the residential.
And the house also, they are now trying to throw her out of the house also, which is in her husband's name, not in the son's name. Lordship.
My lord, may I place this, my lord?
Yes.
This is a purely a civil dispute, my lord. This is a purely a civil dispute, my lord. This is a blast and a counter blast.
Misbehaving with
My
your
lord,
mother.
my lord,
I can understand it's a civil dispute,
my lord,
but you will misbehave with your
my
mother.
lord, I bow down to this court, my lord.
And will beat her up.
No, my lord, I bow down to this
Then-
court, my lord. My lord, let me say.
If you bow down, then first take her to your residence.
My lord, she is residing with me
and behave appropriately.
my lord, she's residing with
Merely saying bow down will not do.
my lord.
Your conduct will show that you are following the norms.
My lord, let me say this, my lord. Every month I have been paying her money order and she is residing with me, my lord. I have the proofs of this money order, my lord. She is residing with me. She's peacefully residing with me, my lord. The other sons and daughters, they are instigating her to lodge an FIR. My lord, on the day this FIR was lodged, that
So
is
you are paying this amount in terms of any order of the.
No, my lord. No, my lord. On my own accord. My lord, and moreover, my lord, the day the FIR was lodged.
650 is the sufficient amount for a living a decent life
subsequently
by a senior citizen.
My lord, subsequently,
Do you have any idea about the price of medicine nowadays? 650.
My lord, subsequently,
What is the salary of your maid servant? Tell me, what is the salary of your maid servant? Who is working under you?
My lord, I understand, man. It is way more than that. My lord, subsequently, my lord.
So on what basis you are paying rupees 650?
No, subsequently it is.
I am asking you on what basis you are paying rupees 650 to your mother.
My lord, earlier I was paying that. Subsequently, my lord, I am paying her 1,500 per month, my lord. My income is a meager amount, my lord. I run a barber shop.
Is it not your duty to take care of your mother?
My lord, the shop room that is in question, my lord, that is a barber shop, that is a saloon, my lord. I earn a meager amount from that.
So are you the owner of that saloon?
My lord, it is registered in the name of my father.
Then,
my lord,
so I will direct the police authority to oust you immediately because you are there as at best as license. So if your mother does not permit you to run that saloon, in that event you have no authority.
My lord, in that regard of the shop room, my lord, a title suit was filed, and in that suit, my lord, I have obtained an order of status quo. My lord, now what has happened when the FIR was
If this saloon is not yours, and it was by your late father,
my lord,
then how you have a right, a proportionate right over it, not more than that.
My lord,
and your other brothers and sisters have also right.
My lord,
if your father died intestate,
my lord,
so if that be so, then how you are paying rupees 650?
My lord,
To
subsequently,
your mother.
My lord, subsequently, I have been paying her 1,500.
Yes,
my lord.
what steps police authority has taken?
I have given.
My lord,
So this case has already, investigation is complete. Charge sheet is filed.
This,
my lord, the earlier
3rd of June, charge sheet was filed already.
this case or the earlier case?
No.
This case.
Case number 15526 dated 23rd May 2026. was started against respondent number 4 and 5 and others, and case has been ended in charge sheet against both the respondents. Both were surrendered on 3rd of June. VD Halishore Police Station charge sheet number 210 dated 25th June 2026. Yes, already charge sheet has been filed in connection in 155/2026. So in that event, in the writ petition, you have prayed for certain directions, but since charge sheet has been filed, I will direct the police authorities to provide protection to the petitioner if occasions to arise this. And you will be also granted leave to approach the jurisdictional authority under 2007 Act for maintenance.
My lord, only one.
Learned advocate affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate representing the petitioner submits that petitioner is senior is a senior citizen and mother of is a senior citizen and respondent number and respondent number 4 and 5 are son and daughter-in-law of the petitioner. Petitioner alleges misbehavior, with her by the respondent number 4 and 5. And a complaint was lodged in connection and a complaint was lodged by the petitioner against respondent numbers 4 and 5 based respondent number 4 and 5. Stop. Based on such complaint of the petitioner, an FIR was drawn up. Consequently, Halishore Police Station case number 155 dated 23rd May 2026 was initiated against respondent numbers 4 and 5. Stop. Petitioner prays for direction upon the concerned police authorities to provide protection. Stop. Next paragraph. Respondent number 4 and 5 are represented by learned advocates who has disputed the contention made on behalf of the petitioner, and it is also submitted that a sum SUM is paid by them to the petitioner month by month. It is also submitted that next paragraph. Learned advocate representing the state respondents has filed a communication dated 14 July 2026 of officer in charge, Halishore Police Station, and same is taken on record. Stop. Copy of the communication dated 14 July 2026 is are made over to the learned advocates representing the petitioner and respondent numbers 4 and 5. Next paragraph. It is disclosed in the communication dated 14 July 2026. 23rd May, this case was registered, and on 25th of June, charge sheet filed.
Yes.
That on completing investigation in Halishore Police Station case number 155/2026 dated 23rd May 2026. Charge sheet was filed. Charge sheet being number 21210 2026 dated 25th June 2026 was filed before the jurisdictional magistrate. Next paragraph. In view of filing of charge sheet, no further order is required to be passed in connection with the criminal prosecution, but concerned police authorities are directed to provide protection to the petitioner if occasion so arises. Next paragraph. Learned advocate, leave is also granted to the petitioner to approach jurisdictional magistrate to approach jurisdictional authority under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. Next paragraph. Writ petition stands disposed of.
My lord, only one indulgence that I seek from your lordship.
Next matter.
Grateful, Lord.
My lord, may kindly restrict the complaint of the
I
petitioner.
have directed when occasions so will arise.
My lord,
Item number 31.
Lordship, we appear for the petition, your lordship. Service is not complete, your lordship. Service is not complete.
You are appealing for?
Respondent number 10 and 11.
Your lordship,
Private respondent.
there are 4 private respondents. 3 of them are showing addressee left without instructions. If your lordship could give some direction that I can do a paper, something of that sort. Although
service is yours, head.
I understand your lordship.
My lord, one thing just
a minute.
the purpose.
Our conclusion.
You have prayed for registration of FIR.
Your lordship, we have sought sanction under 218 because we want FIR against 2 public officials. So we have sought for, on one hand, the sanction. I have made a representation for sanction that has not been considered as of yet. And if it is considered in our favor, then register an FIR. Your lordship will find the application is at page
My lord, recently
40.
Recently,
40
Honorable Supreme Court in categorically stated that for sanction, magistrate is competent to grant. Even without sanction, FIR can be registered. होता है इसमें उससे नहीं पड़ता
Sanction under against whom you are
against the revenue officer and the BLRO, your lordship. Lordship, the issue is, I don't know why the mistake has been made. The state, they have sent service by post, which has not been received. Lordship, the Barakpur 2 BL and LRO and the revenue officer, Barakpur 2, North Chobbish Pargona. North of the municipality.
But it says that 218 subsection 1, it says that shall take cognizance of such offence except with the previous sanction of the other, save as otherwise provided in Lokpal and Lokayukta Act 2013.
My lord, just 1 minute.
Just a minute, it is his petition. Wait. Yes.
Just 1 minute, your lordship.
Now you will see your mobile phone.
Your lordship, I'm just taking out the section, your lordship.
You are appearing without any book in this matter.
Your Lordship, the issue was of regarding service. What has happened, Your Lordship, is they have, for whatever reason,
This will come later. Please satisfy me with regard to the prescription of law under section 218(1).
I don't have the book right now because service was not complete. That is why, because the state has also not been served.
Yes.
My lord, recently, Question Upadhyay's case, Supreme Court clarified this position regarding the sanction. My lord, this is the operative part. Two things. One thing is that first, one has to approach the police, exhaust the police remedy, then can approach the magistrate and cognizance. No sanction.
Sanction is to be accorded by whom? According to you, according by whom?
The sanction has to be by the DM, Your Lordship. Sanction DM has to grant.
So such offences sanction save as otherwise provided. Sanction is to be accorded by whom?
The district magistrate, Your Lordship.
My lord,
according to my
You do not know, but you have filed a case.
Your Lordship, it is not that. It is, the issue is I haven't bought the book, Your Lordship. The problem is the state has not been served.
See section 218. It is to be accorded by whom? Police. If it is not police authority, then why I will take up this issue?
Yes, Your Lordship, magistrate, the district magistrate, Your Lordship.
And then why I will take up this issue?
That is.
I have a jurisdiction determination to take up only selection matter. It is not a case relating to police.
Then it may be released, Your Lordship.
Please.
Then it may be released, Your Lordship, for assignment.
Yes.
It may be released for assignment to a proper bench because it's charge or magistrate, Your Lordship. So the DM is the appropriate authority. The DM will grant sanction. And if the DM does not grant, if it grants sanction, then the police will register.
Who is to provide such a sanction?
My lord, magistrate. My lord,
magistrate. If magistrate does not grant sanction, in that event, whether it is this matter is to be considered as a police in action matter?
No, it will not be, Your Lordship.
My lord, this point, paragraph 164 of the latest judgment, Question Upadhyay's case, Supreme Court clarified that. After setting aside Delhi High Court order, Delhi High Court held that sanction is required. Before registering an FIR, sanction is required. Supreme Court clarified, no sanction is required. Magistrate can take cognizance and FIR, magistrate direct to register FIR if the complainant exhausted the police remedies. That is, first he has to approach.
But if the complaint is to be lodged against an higher official than magistrate?
No, my lord.
Then how magistrate will deal with the issue?
Well, his prayer is mingled with.
No, I'm asking you. If complaint is to be lodged against the higher official than the magistrate.
Yes, that is there.
There is an indication under section 318(1).
That is all.
Then whether the magistrate can tackle the issue.
No, here his case is the magistrate has not registered directed to register the FIR. Here his case is that magistrate.
Here case is that he is not that the authority is not sanctioning. He is not according sanction under section
second part. The first part FIR.
Now whether this is a case which comes under my determination, I am asking all of you. It is not a police in action matter.
No, that is not there. That is not there. But he mixed, my lord. He mixed with the FIR and sanction. First paragraph A, prayer A, he mixed that police has not registered FIR and government has not sanctioned for
the state.
Pardon?
Who is for the state?
Your Lordship, that is the issue. The state has not been served. They have served it by mail. That is the issue.
My lord, this is Sujal's case. After that,
why you have not served upon the state?
They, for whatever reasons,
Who is that
service has been made by.
2nd of July, matter was filed. Today we are on 14th of July.
Service was done.
And it is indicated that matters to be listed on 13th of July 2026.
Service.
Why it is indicated in the list?
Your Lordship, it was served, Your Lordship, but they have served by post and it has come returned.
Show me that acknowledgement issued by the Office of the Learned Government Printer.
Your Lordship, it was served by postal receipt.
What is this? You are wasting court's time.
I was indicating the
initial phase. Why you have stated in the presentation form that matter is to be moved if it is not possible for you to complete service?
No, Your Lordship, we had sent service, Your Lordship.
At the time of call,
Your Lordship, kindly seize the affidavit.
Praise for accommodation to effect service of notice upon the respondent.
117.
However, you are representing?
10 and 11.
10 and 11.
Respondent.
I have a respondent number 10 and 11 are represented by learned advocates. Next paragraph. Hearing of this matter stands adjourned. Learned advocate for the petitioner is directed to serve notice.
Lordship,
from,
kindly see
non-appearing respondents.
the affidavit service.
Office of the learned government pleader by fortnight from date and file affidavit of service on the next date. Next paragraph lists the matter under the heading motion non-service in the monthly combined list of August 2026. Next.
My lord, this well, it has been clarified in this case.
I will consider let them come after making the matter ready in terms of service.
Item number 32. 32, I am for the petitioner, my lordship. Affidavit of service. My lord, may I submit?
ये mute করে দাও তো live streaming টা. Yes. Yes.
Your petitioner
তুমি associated? Item number 33.
My lord, I am for the petitioner. Here the prayer is for registration of FIR. Now, as per your lordship's view, I have to approach the magistrate. But kindly give me the liberty to approach the magistrate.
At the time of affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, learned advocate representing the petitioner prays for leave to approach the jurisdiction magistrate since grievance of the petitioner is in spite of lodging complaint, same has not been transformed into an FIR. Next paragraph, state respondents are represented by Mr. Das, learned additional copy. Next paragraph, since there is an alternative remedy available under section 175(3) BNSS 2023, in the event complaint is not transformed into an FIR, comma, liberty is granted to the petitioner to approach the jurisdiction magistrate accordingly. Next paragraph, writ petition stands disposed of, parties to act on the server copy. Next.
I'm grateful, man.
Item number 34.
My lord, in item number 34 at the very outset, my lord, I am appealing for the bank, my lord. I would beseech my lord to give me at least a week's time because the alleged incident is of 2023 and that it took place in the state of State Bank. It took place in the state of Rajasthan. Rajasthan.
Just one development has taken place today. I have received email in reply to my service, which I have done on by email from the Rajasthan Bank, the head office,
Bank of Rajasthan.
SBI Rajasthan head office, which requested to freeze my account. That for unfreezing my account, I should contact the branch of SBI Sharshuna.
So you
my client immediately went to the branch. There he was informed that since the court case is in before your lordship, they cannot do anything.
My lord, let me take instruction on this.
Just today, my lord, I have received.
I have copies out.
But it says last two lines for removal of hold lien. Please contact the concerned law enforcement.
May I indicate one
Agency,
page?
the relevant contact details. So bank.
I do not want.
I'm not today. I'm not saying anything. Let him take.
May I indicate just one page? The lien is only with regard to 1,750. My account has more than 1 lakh.
What is the stand of the bank?
That is on record. I have annexed that document.
Matter is heard in presence of the learned advocates representing the petitioner. State respondents, you are for the state.
I am for the Union of India.
State of West Bengal,
Learned Union.
Representing the petitioner and respondent authorities. Next paragraph, learned advocate or Mr. Saha, learned advocate representing State Bank of India has prayed for accommodation to obtain instruction. Next paragraph, Mr. Singh, learned advocate representing the petitioner relies upon an email letter dated 14 July 2026. This was issued by whom?
This was issued by the SBI officer of Jaipur. Who has requested?
Where from you are getting this SBI officer?
Kindly takes the email ID LHOJAI. I have indicated this email ID in my cost title as well.
LHOJAI.
LHO is local head office of local head office of Jaipur.
He is AGM of Jaipur.
Like this head office is the local head office of Kolkata.
Mr. Singh, learned advocate representing the petitioner relies upon an email letter dated 14 July 2026. Issued, purportedly issued by authorities of State Bank of India at Jaipur or Jodhpur. Jaipur. Stop. Copy of the letter dated 14 July, email letter dated 14 July 2026 is placed before this court and same is taken on record. Next paragraph. Learned advocate for the learned advocate for State Bank of India being respondent number 5, 6, and 7 is directed to obtain instruction and to file relevant documents on the next date as to why bank account of the petitioner was debit frozen. Stop. Hearing of this list the matter under the same heading on 30th July 2026.
May I file the affidavit of service?
Yes. Affidavit of service filed on behalf of the petitioner.
All the track reports, my lord, are separate, my lord. They have been.
All are appearing.
My lord, Jaipur authorities are not appearing.
Generally, outstation authorities are not represented in this matter. Let me see.
Grateful, my lord.
Item number 35.
Remove that this debit freeze tag, and the involved amount can be marked as lien.
The disputed amount.
That is what the bank authorities are doing. so that petitioner can operate his account. Yes, 34.
Item number 35.
35, my lord.
35.
May please, your lordship, I appear for the petitioner, my lord. Very short point involved, my lord. Nothing on documents. I am the owner of a flat in a building.
What you are praying for?
I am praying for, I'll just indicate. Lordship, give 30 seconds, my lord, I'll indicate, my lord. My flat.
Just a minute.
Yes.
Give me 30 seconds to
Yes,
go
yes,
through
my
your prayer. Whether the complaint is transformed into an FIR?
Nothing has happened. Well, we are not aware. The private respondents, my lord, are the maintaining authority of the lift. They have nothing to do with
transformed into an FIR. If at all investigating agency finds it's apt to do this. So if you are agreed by the inaction on the part of the police authority, you have to approach the jurisdictional magistrate.
Not
Article 226 code.
Some scope. I'm not even going into whether 226 scope in some or cases, my lord, I can, my lord, bypass 175 and come, which was originally 156.3. But I am not even on that.
Jurisdiction magistrate.
I am only praying for the police to give me, my lord, appropriate, my lord, No, not a private dispute.
Private dispute.
This is
Lift is not working.
because of
Lift is not working. We inquired into the matter. Well, it is the liability of the promoter or the developer.
No, lordship gives
Affidavit of service filed on
lordship gives me, my lord, one last chance. My lord,
petitioner is not. Yes.
Just 10 seconds. I'll bow down to whatever my lord decides. My lord, my private dispute is with the developer. My complaint isn't against the developer. The complaint is against.
Complaint is not transformed into an FIR. Then first you have to approach the jurisdiction magistrate. If the alleged offense is a cognizable offense.
Upon investigation, I am saying, well, today my 70-year-old mother, it's a lift. The respondent number 8 and 9 have nothing to do with the property.
Mr. Rai is submitting that the offense which is reported to the police authority is not a cognizable offense.
Yes. Then
in case is not in case of incognizable offense, non-cognizable offense,
they can refuse to take cognizance.
The authority has to obtain appropriate order from the magistrate
before taking the file, lodging the FIR. Some protection at least so that I can operate. At least protection so that I can operate. Respondent number 8 and 9 will have switched off the lift.
Next paragraph, learned advocate representing the petitioner. Petitioners submits inaction on the part of the concerned police authorities in taking steps based on the complaint lodged. However, it is submitted that as yet no FIR has been drawn up. Stop. Prayer is made in this writ petition directing the police authority to take necessary steps in consideration of the complaint lodged by the petitioners. Next paragraph, Mr. Rai, learned government pleader, is representing the state respondents who submits that offense reported to the concerned police authority is not cognizable offense requiring drawing up of FIR. Next paragraph. If petitioner is aggrieved by the inaction on the part of the concerned police authorities, since complaint lodged by the petitioners is not transformed into FIR, in that event, petitioners are required to approach the jurisdiction magistrate under section 175(3) BNSS 2023. In this regard, reliance is placed on the judgment of the Supreme Court reported in 2007 6 SSC 171 Alu Padamsi and others versus Union of India and others. Next paragraph. Hence, present writ petition is not interfered with, is not entertained, and same stands dismissed. However, this order shall not preclude the petitioners to approach the jurisdiction magistrate in pursuit of remedy. Parties are to act on the server copy of this order.
Because your lordship has given me the liberty to approach, my lord doesn't use the word dismissed. Lordship disposed of in accordance with because the liberty.
At least past 500 similar orders.
Extremely grateful. I'm most grateful, my lord.
Item number 36.
I'm for the petitioner.
Yes.
It's a petition number one, file a complaint, that one PS case 215, 2022. Thereafter,
This is your FIR, page 14.
page 14, it's another FIR, page 14.
Your persuasive complaint. Persuasive complaint. There are two FIR already been lodged. The accused, they were taken into custody. In third complaint, she lodges a written complaint where it was found that when the time of occurrence, that point of time, the accused already in custody.
I pay the private respondent. On the date of complaint,
Kindly see the last page.
as my learned senior friends submit, my lord, I was in jail custody, my lord, judicial custody, my lord.
When
this complaint comes up,
of.
my lord. This malicious complaint coming up repeatedly. And another thing, my lord, I want.
You tell me that when this complaint was lodged.
But I am submitting, my lord. My lord, the FIR lodged against the respondent, private respondent.
Two FIRs.
First two FIR was lodged in the year of 2022 by.
You are not required to place history.
My lord.
Last FIR when lodged? When the complaint lodged?
First June 26.
I'm
When it was lodged?
Last FIR.
My lord, that is on 1st June 2026, page annexure 2, page number 17, my lord.
17.
That and I was in custody in related to this FIR, my lord, when the complaint comes up.
It is submitted that the accused person was in custody on 1st of June 2026.
Mithun Das, he is the principal accused, he was in custody.
I was in custody.
That is let me 1 day's time, my lord. I have to take instruction, my lord. Without instruction, my lord, this is my fault. I am admitting this, my lord. Only 1 day, my lord. I have to take.
And the complaint says that then
I am
it is alternative remedy available, my lord.
And anyhow, my lord, if your lordship find this complaint is maintainable, then the alternative remedy comes, my lord. They can go before the concerned court.
My lord,
and their prayer is to not consider even, my lord. They have not even set a prayer for a consideration of their complaint also. They have asked to arrest.
For in the writ petition?
Prayer is not even maintainable, my lord.
No, my lord. My lord, for the police.
What you have prayed for in this writ petition?
For police protection, my lord.
Their prayer is for
the complaint. The accused person is in custody.
First, my lord, 3 FIR was lodged against the private respondent number 4 and 5. And the number 4 complaint was filed against the same private respondent, my lord. My lord, kindly see the letter of.
No, your prayer is by arresting the respondent number 5 and 4 and 5.
My lord, kindly see the prayer of the writ
by
petition.
arresting the respondent number 4 and 5, mandamus to issue commanding the concerned person to give police protection to a petitioner. Issue.
My lord, kindly see the prayer number B, my lord.
Sir, filed at affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Stop. By presenting this writ petition, comma, inter alia, comma, prayer is made.
My lord, kindly see the prayer number B first.
For a direction upon the concerned police authorities to take steps in connection with Daton, D-A-N-T-A-N, Daton Police Station, case number 182/2026 dated 1st July 2026, which was initiated based on the complaint lodged by the petitioner. Stop. It is also submitted that accused person is required to be apprehended. Next paragraph, Mr. Learned Advocate representing respondent number
4 and 5.
Respondent number 4 and 5. And Mr. Rajdeep Mujumdar, Learned Additional Advocate General representing the state respondents have jointly submitted that on the date when FIR was drawn up based on the complaint lodged by the petitioner, that was 1st June 2026, accused person was in custody. And as such, there is no question of taking the accused person into the custody, as prayed for in this writ petition. Next paragraph. Having considered the case made out in this writ petition and taking note of the submission made on behalf of the respondents, it appears that accused person is accused person in Daton police station case number 182/26 dated 1st of June 2026 is still in custody.
No,
He's still
No, my lord, this is means in
he's on bail.
he was in bail, my lord.
Very well.
But when the complaint was made, my lord, he was in custody.
No.
But the
private respondent.
no,
No, it is further submitted. You can't add code. It is further submitted that at present, respondent number, which respondent?
Four, my lord.
Respondent number 4, being the accused, is enlarged on bail. Stop. Next paragraph. তারপরে কি বলছিলাম? না ওটা দরকার নেই, ইট অ্যাপিয়ার্সটা কেটে দাও। পুরো ইট অ্যাপিয়ার্স থেকেই কেটে দাও, পুরোটাই কেটে দাও। Considering the case made out in this writ petition and submissions made by the respective parties, today prayer of the petitioner is a direction is for issuance of direction upon the concerned police authorities to take necessary steps in connection with aforesaid criminal prosecution. Stop. If petitioner is dissatisfied with the actions taken by the concerned police authorities in connection with the aforesaid criminal prosecution, in that event, petitioner is required to approach jurisdictional magistrate under section 175(3) BNSS 2023. Stop. In this regard, reliance is placed on the judgment of the Supreme Court reported in 2026 SCC online SC 798 within bracket Sujal, Vishwas, Attawar and another versus State of Maharashtra. Next one. Hence, present writ petition is not entertained, same stands dismissed. Parties to act on the server copy. একটা শেষে লাইন add করে দাও. However, it is made clear that this order shall not preclude the
order of
petitioner-
peace and tranquility, my lord.
দরকার নেই, dismiss করেছি। Take it back, Mr. Mojumdar. I'm not. I have not complied with it. Next. হ্যাঁ, 3টে থেকে ওইগুলো ধরো।
Item number 77.
কালকে আমরা বসেছি।
Yes, report by the subdivision officer. Several orders were passed in this matter. There was a previous order passed by the coordinate bench. Where is Mr. Das? That report is necessary. And that is report by the subdivisional officer, Arambagh subdivision, Hooghly. Respected citizens. No.
কি রেজিস্ট্রেশন নিয়ে দেবো?
At least previously 3 orders were passed for passing such orders. For filing such report. First order was passed on 17th March 2026, and thereafter series of orders. Yes. Adjourned for a week, no order, because previously there was an order that if no appropriate order shall be passed. Mr. Das, go through the first order, which was passed on 17 March 2026. And then order dated 8 April 2026. So subdivisional officer, Arambagh subdivision. is required to file report. Several occasions matter was taken up for consideration. Subsequent to the initial order passed on 17th March 2026. Simply adjourn till next Tuesday. But I am expressing my mind, Mr. Das. If I find that the subdivision officer does not file report, I will direct the subdivision officer to appear before me personally.
Kindly make it Thursday instead of Tuesday, my lord. Instead of Tuesday, make it Thursday, my lord.
You are appearing for whom?
I'm private respondent, my lord. And as your lordship, my lord. Kindly, my lord.
Support that prayer, Lord.
Only Thursday, my lord. As your lordship, my lord.
The 23rd July, Thursday.
Great, lordship. Great.
মার্ক করে রাখবে তো
কটক তো হয়নি Grateful. Grateful.
Item number 78.
May it please, Your Lordship. My Lord, kindly takes up order dated 11th of March 2026 and 13th of May 2026, my Lord. The entire backdrop of the case, my Lord, has been recorded by Your Lordship. First 11th of March, my Lord.
What is the outcome of mediation?
Mediation has failed, my Lord. Lordship, kindly sees, my Lord, the report, my Lord, if it is there, my Lord, because Your Lordship had, my Lord, called for that mediation report.
Yes, mediation failed.
This is a case, my lord, where a mother and a son, mediation ought not to have been failed. That is
You are
my
agreeing for whom?
For private respondent.
Then matter has to be heard on merit.
absolutely.
Who is
my lord.
agreeing for the state? Because it was
Oh, yes, 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 yes.
directed at the point of time
No, no,
when
your lordship.
there was a separate panel.
And your lordship is correct, my lord. That is something it's my fault. My lord, then your lordship, my lord, made, if your lordship so desires, my lord, if someone could be engaged and regularized, my lord, in your lordship's court.
Then Surjanil Das be
Let Shujunil Das. Absolutely, absolutely, my lord.
additional government people. Court has perused the final report. Court has perused final report dated 23rd June 2026 of the mediator, which was communicated to the joint registered within bracket court with a letter dated 24th June 2026 by the officer in charge, mediation center, High Court, Calcutta. Next paragraph. As it is reported by the mediator, at a report dated 23rd June 2026, final report. As final report dated 23rd June 2026, discloses that mediation failed. Writ petition needs to be heard on merit. Stop. Next slide. Today, petitioner and respondent number 6 and 7 are represented by learned
5 and 6
and 7.
The first order records 5 and 6.
No, 6 and 7.
Very well, 6 and 7.
6 and 7 are represented by learned experts. Next slide. However, state respondents are not represented. Next slide. Mr. Surjanil Das, learned additional government pleader, is requested to appear on behalf of the state respondents. Hearing of this matter stands adjourned. List the matter under the heading. List the matter under the same heading on 4th August 2026.
Much grateful, madam. Much grateful. Unfortunate, madam. Mother and son mediation failed. It's unfortunate.
আমি একটা দাঁড়াই
Item number 79 to 82.
Well, there are cross petitions, my lord. The first one, I am the petitioner, my lord.
My
lord's pleasure.
first one,
second last order, my
May I just say this before your lordship, my lord? Item 82, which is, my lord, my writ petition, my lord, WPA 27942, which is earlier in time, and my lord, everything emanates from the order passed in that writ petition. My lord, if that could be taken up first, my lord, because I am the petitioner in that writ petition, and an order was passed. Subsequently, some action was taken by the investigating agency on the basis thereof, being aggrieved with which, my lord, if I have rightly understood, Mr. Bhattacharya's client has come.
No. Absolutely
Lord,
not. But these
Lord,
matters
let
are
me-
heard by your
Lord,
lordship,
let
my lord.
me-
Bank freezing, my lord.
Let me not be.
He has called for a report from the investigating
Then
officer.
let
my lord.
him
This is
say,
the
my
second
lord.
last order by your lordship, my lord. It's a very detailed order,
Yes.
my lord, 19th May 2026.
My lord, kindly have the first order of Justice Shubhra Ghosh of 17th December 2025.
Just a minute.
Everything emanates from there.
Well, you are aggrieved by the letter dated 12 January 2026.
I'm obliged, my lord. Your lordship was kind enough to record.
And this letter was a sequel to the order passed by the court
my
bench
writ
on the
petition.
writ petition filed by Mr.
Lordship.
Chatterjee's client.
That is
My
what
lord,
I'm
page
trying to say.
63, my lord
That
was
is
kind enough to record, my lord, cross
These were
submission.
the state respondents.
Order dated, my lord,
Yes.
21st of April, my
What is
lord.
the basis of letter dated 12 January 2026? Show me.
Yes, my lord. I have a report, my lord. Kindly have.
Freezing your bank account.
I'm deeply obliged, my lord. That's the only issue in this case, my lord, the first one.
Where I had put in money, my lord. That's my case in the FIR. That's
But it's
my
not
writ
for
petition.
punishment, the present.
That's my writ petition.
Dissatisfied or
It was done pursuant to the High Court's order. Let kindly have a look at my FIR, my lord.
Just a minute. Nothing.
I'm not going to expose this. 26. 40.
What is the amount lying in the account?
My amount is 2 crore 40.
That I've seen.
But it's 44 lakhs some odd. Number the FIR, if your lordship sees, my lord, page 23. It's eloquently vague.
No, I was thinking, or rather contemplating that if the amount is greater than 2.41 crore, in that event, keeping this 2.41 crore as lien.
No, but it's lesser than that, my lord. I have taken the instruction.
Could be permitted, the account holder can be permitted to operate that account.
No, but
if it is
much
if it
below,
is
my
less
lord.
than
Right, my lord.
2.41 crore,
Right, my lord.
then
Then
if
these
the
arrangements-
account goes by taking advantage of the order which court is contemplating to pass today, then what will be investigated?
Well, I just took full submission subject to my lord's acceptance. A is, my lord, if your lordship sees the FIR, the story is I have invested, I wanted to become a director, I became a director, then you inducted someone else, I am not happy.
106 provides that 106(1), earlier 102.
I'm obliged, my lord.
That yes, seizure of property does not include seizure of bank account by issuing prohibitory order. But when that was the order passed in 1993. So from 2000 onwards, due to advancement of information technology, now the bank account is easily accessible by a click of a button.
Your lordship is right, my
And
lord.
when the complaint is concerning the account itself,
Yes.
then if the account goes, what is to be
I
investigated?
just tell your
upon?
lordship, my lord, twofold answer. A, my lord, criminal proceeding under no circumstance is a recovery proceeding. B, my
Mr.
lord,
Bhattacharya, if your account in your account more than 2.41 crore is lying,
right, my
in
lord.
that event, court can keep that amount as lien, that involved amount,
But that is not
alleged
happening,
involved
my lord.
amount,
It has
and the
fallen
rest
from
of
your
the
lordship, but-
account can be
My lord,
operated
I
upon.
am assailing that.
Otherwise, you have to wait.
My lord, I have a request, my lord. Give me just 30 seconds. The points I formulate, I leave it to your lordship's discretion. A, my lord, just by filing an FIR as a recovery mechanism, my lord, my account cannot be frozen. NCLT proceeding could have been there, my lord. A criminal proceeding is not a substitute. Number,
Answer the query,
please, my
which
lord.
is to be made by 10 seconds.
Please,
That if this account goes by taking advantage of the order passed today, then what is to be investigated upon?
My lord, the crime, not the recovery. I'm obliged, my lord. My lord, there are at least 10 judgments I've learned from your lordship, my lord.
Proceeds of the crime is required to be.
I'm deep
protected.
obliged, but 107. My lord, I bow down to your lordship. 107, which requires magisterial order. Where is that, my lord? There are two judgments directly on this point by this honorable court.
No, 106, there is no requirement of
My lord,
magisterial order.
proceeds of crime is
That is with regard to that is with regard to
My lord, if I may, my lord, see,
attachment.
I'm obliged, my lord. Seize 106, my lord. There is no proceeds of crime.
My lord is absolutely right.
Attachment, forfeiture, and restoration. But
Yes.
seizure is contemplated under section 106.
I'm deep.
My lord,
Now,
seizure,
if issue is relating to operation of account or freezing of account, visa way, permission to be accorded by the dint of the court's order to operate account. If this account goes, if accounts does not survive,
right?
then
my lord.
what is to be investigated?
But the punishment, I mean, crime has to be investigated. Nothing beyond that.
Then
Number two, my lord, kindly appreciate.
and today
107.
court is considering this writ petition at the motion stage.
Yes.
My lord, right?
Well, file your
My lord,
affidavits,
just
court
give me 10 seconds, my lord. I have tried to answer your lordship. My lord, after advent of BNSS, my lord, it's only 107. 107 cannot be invoked. 106 cannot be invoked, my lord. 106 is equivalent to 102. Your Lordship has rightly pointed out 1999 judgment, my lord, of the
93 judgment.
93 was negative, my lord, in my favor. 1999 said yes, property includes, my lord, that Niyogi case which was originally from
And
Bombay. High
it
Court.
should be the perception that why property does not include bank account.
My lord, there is a judgment exactly on 102.
When
that-
you are making a will,
right, my lord.
then the bank account will be excluded.
Well, I just tell you, Lordship, my lord. This, but so, my lord, immovable property will be included, my lord. Apropos this, allow me to, my lord, respond. According to Supreme Court, 102 excludes immovable property, my lord. Sees 102 language, my lord.
This will be considered after
No,
acceptance.
but issue is, but
my
my
lord,
lord,
this-
this-
my lord, what
there's
is to
no
be
scope of
decided in the
interim
on
order.
affidavits in that event, Mr.
my lord, only issue is that I cannot, my lord, the company owns, my lord, a tea estate. It cannot run the tea estate,
account
my lord.
will be withered away. If today I pass an order,
This is not the forum, my lord. Police is not a recovery mechanism, my lord. My lord, just give me, my lord, 107, there are two judgments your lordship
and
is
not
aware
only
of.
this, Mr. Bhattacharya, this order, this seizure of account has been claimed pursuant to the order passed by the coordinate bench.
No, my lord, see page, my lord,
Yes, yes,
63.
December order.
But I'm sorry, it's not so. See
17th
page
December
63, my lord. There is an observation, no account has
Because
been
he is the
processed.
complainant, he was not satisfied with the steps taken by the police authorities, and the writ petition was filed.
Yes.
Therein, an order was passed. As a sequel thereto, your account was.
My lord, the order says that no
order has
account
not
has
been
been.
appealed.
My lord, this is the difficulty. Any question to me, my lord, my dear friend will always over anxious, my lord, to cover me, my lord. I just tell you, lordship, my lord, 107. First of all, my lord, in that order,
If you could have satisfied this court that no, your account, there is an.
no, my lord, it's not there. My lord, improper fact I will never place before your lordship. That I will never do.
Proceeds of the crime needs to be protected.
My lord, proceeds of crime in 107. My lord, kindly seize 107.
Not
The
proceeds
word
of
proceeds of crime is not there in 106. Which is why, my lord, after BNSS, there are 4 High Court judgment, my lord, that it is only 107.
It's
And
stolen
we have,
property.
my lord, 2 judgments of our High Court.
410
And there is no
IPC.
contrary judgment.
My lord, it's stolen property. 406 is there.
Come to section 106, subsection 1.
Please, my lord.
Absolutely stolen.
Read it, Mr.
Stolen
Bhattacharya.
property. Yes.
Subsection 1, my lord.
Yes.
I'm obliged, my lord.
106, subsection.
Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may have been found under circumstances which create suspicion of the commission of any offense.
So then where is the wrong? If with this suspicion being driven by this suspicion, investigating agency freeze your account.
My lord, apropos this, my lord, seize kindly, my lord, the compilation I have handed over, my lord, page 1.
No, I'm asking you. Then
Because they are, my lord,
where is the bar? Or where is the wrong so far the
Like
steps
your
taken
lordship,
by the concerned police
wrong
authorities
is
in furtherance to section 106(1).
after introduction of 107, there is a fasciculus provided in order to, my lord, attach a bank account. Now, my lord, what has fallen from your lordship, kindly appreciate. This is very important. That if the account goes, then everything goes. So therefore, what they want effectively, this is attachment of my account, my lord.
My 2 crores have already gone. Only 40.
And you have not gone to the civil forum. You have activated police. So proceeds of crime, my lord, the terminology is absent conspicuously in 106.
Yes, it's stolen property.
And
which
this
is
issue, my
defined
lord,
under
exactly this
317.
issue was dealt with, my lord, by this honorable court and other honorable courts as well. SLP stood dismissed.
He has already taken away my 2 crores, my lord. Let him deposit those 2 crores with the Honorable Registrar General, my lord. Then, my lord, let him argue law.
Mr. Chatterjee, you will not decide.
And
Honorable
three-
judge will
No,
decide.
I am making a statement to the
No,
court.
don't
not
make
to you, sir.
this sort of statement.
Stolen property is
But
defined.
the term proceeds of crime, I'm sorry.
317 of the BNS, stolen property is defined.
No, this is an attachment procedure.
I'm obliged.
Under section 106.
Right.
But
107, my lord, subject to correction.
under section 106(1). Now, if this is the attachment procedure, I am asking you that power of seizure of property, how that is affected.
My lord, the power of seizure is only for, my lord, investigation which excludes bank account that has been dealt with, my lord, by 4 judgments, by 4 different high courts, including this honorable court in 2 judgments. Number 2, my lord, what has rightly fallen from your lordship, that while if the money goes away, my lord, I'm just, my lord, so far my argument is not a recovery proceeding, my lord, without prejudice to that, let me answer that. So therefore, my lord, the money has to be kept intact. So that is effectively attachment. And attachment has been provided under 107, and there is a mechanism provided. And my lord, kindly appreciate, under 107, they can have an ex parte order also. It's not that I have to be notified. 107 contemplates passing of ex parte order. Only what is required, my lord, homologation by a court of law.
Is it your submission that under 101, 1061, investigating authority is powerless?
To attach any bank account, my lord.
Show me the
My lord, kindly see, my lord, the one, my lord, compilation was handed over, my lord. It will be on the record, my lord.
I don't think I have a copy.
We had given, sir. I had given you personally on that day in court.
Personally?
But it's there, my lord.
And we have lost it.
And we have lost a copy. Or, my lord, if your lordship so permits, but it was given, my lord. I've given perhaps
fine.
Soft copy. Has your lordship got it? I'm sorry, my lord. My just no, otherwise I have a soft copy, my lord. I think
Circulate the compilation.
that
then,
was
my lord,
done,
and
my lord.
come
Now
and-
I am also without bereft of any compilation, my lord.
Because, my lord, today I might not be able to assist your lordships, my lord.
I have here put judgments.
We'll put in our affidavits, thereafter, my lord, we'll decide, my lord.
That would be better.
This was, my lord, somehow, my lord. Then it's definitely, I will say, my lord, this is, I will take the responsibility, my lord. But it was prepared file, my lord. Well, it's my responsibility, my lord.
No, but I would prefer to have a hard copy of those judgments.
Definitely, my lord. Can I come back tomorrow or day after, my lord? It's very, well, your lordship will decide. I'll just take 10 minutes of your lordship's time. I'll satisfy your lordship. I'll leave it to your lordship's discretion, my lord. Let me
Subject to
put
my
it in this
friends-
way, my lord.
And where is the order of justice goes on?
63.
17th of December 2025.
No, no, it's there, page 63.
This is the record also in my writ petition, my lord.
Not required.
My
In
lord,
this,
this is
Petition by one.
my lord, in this, it's
Saha.
63.
Just
my client.
Just
Yeah,
minute.
this is the order, my lord.
But in this petition also, page 63, same order. Order will never be changed, my lord.
The same order, my lord. In
We would like to show it.
that
But
was
that
the
is
first in
WPA
time. This
2794.
is the first in time, my lord. Hence, I wanted to, my lord, place it before.
No.
My lord,
27492, my lord.
There are two CRR applications.
No, kindly do not consider them at this stage.
my lord, one CRR, one CRM.
Writ petition
27942.
একটা তো ওর রিট পিটিশন একটা দুজনের
Item 82, my lord. Item 82 of the day's list.
Oh, your application is CRR application? No.
No, no.
My lord, it's read, my lord. The first one read, there is another.
কোথায় গেল?
But it's in the list, my lord. It's second last.
82, no?
Nah, the last one.
Item
It. No, no.
Yes.
It's last. It.
It is dated 26 February 2026.
No, my lord.
December
17th
70.
17th December, my lord, in WPA
Yes, yes, yes.
27942. Kindly see the third paragraph. Starting. Acha, my lord. It appears. Oh, acha.
এখানে পড়ে যাবে।
No, it was not decided there.
No, my lord, my submission is, my lord. No, I have not said. What I have said is from the third para, my lord, starting with it appears. But I'm placing that para, my lord.
Yes,
It appears from the report that in course of investigation, the IO has visited the company of the accused and has recorded the version of the issue stated by the manager and head clerk, which, my lord, indicates the defense version of the case. The report does not indicate whether the truth and veracity of such version has been ascertained. The complaint gives a different picture altogether. There has hardly been any, my lord, these are the findings of the court. There has hardly been any progress in investigation, though admittedly, the petitioner has parted with an amount of 2,41,50,000 in favor of the accused. The money trail has not been tracked. No bank account appears to have been frozen. My lord, this last sentence, my lord, I am heavily banking on. No bank account appears to have been frozen.
And no money trail has been established.
And no money trail has been tracked. So, my lord, this is a clear indication of the High Court, and this order has not been appealed against.
This order need not be,
Instead,
because the
another
order
petition has
never
been
says
filed.
you go and freeze. Even if, my lord, I extrapolate that without following the procedure.
What I just I didn't.
What more the High Court needed to say, my lord?
I omitted to read this sentence. This no bank account appears to have been frozen.
Right, my lord.
So therefore, thereafter, if it is frozen,
this cannot be in terms of High Court's order, my lord, when there is a specific provision.
But
My lord,
under
kindly appreciate, my lord,
26,
kindly appreciate. Let us, my lord, go back to basics, my lord.
226 High
My
Court
lord,
is entitled
according
to
to,
monitor
my
the
lord, according to
investigation.
the administrative law, police or any authority cannot be directed to act. You act contrary to law, my lord. So High Court, even if, my lord, we extrapolate this, then they have to follow 107. That's the first point I have, my lord.
Then this order had to be appealed.
then you prefer a review.
But no, this order never said so.
You prefer a review petition.
But this order never said so. But kindly appreciate this. At the most, my lord, after this order, police could have applied before the magistrate that look, there is an observation, so we are applying, you pass an order. My lord, these cannot give, my lord, a carte blanche to police, my lord, to obviate 107. A detailed fasciculars provided they are, my lord, it's compulsory for them to drive a coach and four through that fasciculars, my lord. Kindly appreciate, my lord. If High Court observes, my lord, kindly step back from this case. In any case, my lord, in a given case, High Court observes, there is no progress in trial, but trial has to be properly, I mean, there should be proper progress. My lord, can that be said that the procedure envisaged under the code, my lord, will be given a go by? And therefore, my lord, hardly there will be a conviction arrive. 107 is the procedure, my lord. At the most, the police could have applied with the magistrate for ex parte.
106 cannot be invoked.
My lord, because I just tell you, Lordship, my lord, three reasons. A, after 107 being introduced, my lord, which specifically deals with attachment, which was not there in CRPC, my lord. Therefore, the attachment specifically and squarely dealt with in 107. Therefore, 107 has to be done. A. B, my lord, what?
But why it will not be? It will not come under the expression seizure of any property.
My lord, the seizure is, my lord, if something is done, my lord, that for the purpose of investigation. I just tell you, Lordship, my lord, there may be, my lord, that due to the offending weapon, there is a murder or there is a body assault, my lord. So therefore, the offending assault will be, my lord, seized. But here the money has to be secured, my lord. Kindly appreciate.
Not offending, seizure of any property.
Right, any property relatable to that.
Seizure of any, it says exact connotation is
stolen property.
Stolen or
which may be found under any circumstances which create
or suspected to have been stolen, or which may be found under circumstances which create suspicion in the commission of any offense.
Right, but so
so why it will not come under the expression used under section 106(1).
My lord, there are two ways of looking at it. For any provision, if the words are otherwise clear, my lord, generally that will get, my lord, general interpretation. That's the general meaning.
And that too, it has to be considered in the context of the observation made by the coordinate bench in the order dated 17 December 2025.
Because, my lord, in that case, they ought to, my lord, just apropos the first, my lord, there are two questions, my lord. So for the first question is concerned, my lord, there is no attachment conceptualized under 106 is only for seizure. Now 106, my lord, rather 102, which was the pre-runner of 106, my lord, was interpreted, and any property was interpreted to be only movable property by the Supreme Court.
Only
movable property. But kindly appreciate the wording. Apparently, any property should have been, my lord, immovable also. Supreme Court said no. By interpretation, we are saying this will be immovable. This will exclude immovable. Now here,
excluding immovable
immovable property. So by way of interpretation, an original judgment of Bombay High Court. Now here, my lord, 107 specifically deals with attachment. And what has rightly fallen from your lordship that he requires attachment if the money, goes away, then what will happen? If money disappears. So it's effectively attachment, my lord.
Already 2 crores
So
evaporated.
therefore, my lord, there is a specific provision for attachment. And exactly this issue was dealt with, my lord, by 4 high courts. SLB files stood dismissed. Our high court has also adopted this view, my lord. I'm sorry, my lord, I should have come with another copy of the compilation, my lord. I'm sorry.
Let it be decided on affidavits then, my lord.
But this is only question of law. I'm not relying on any facts.
Already 2 crores
Rather,
gone
give us-
away, my lord.
No, but
Now
kindly
44
appreciate,
lakhs
my lord,
only
his
left.
cry. He wants, my lord, this is where I join issue when I will be arguing, my lord, the quash petition before your lordship. It's basically and effectively, my lord, a recovery mechanism in a criminal court. My lord, at least 10 judgments I have learned from your lordship where Supreme Court said a criminal proceeding cannot be a recovery mechanism.
file for
It's a
quashing then.
406. My quashing is
Let him
before
file
your
for
lordship. If I have a good case or prima facie case for quashing, I have a prima facie case, my lord, for defreezing of the account as well. Because in the meantime, you
If the complaint is that the proceeds of crime, that is, or that particular account is repository of proceeds of crime, and that is the only complaint.
Right, my lord.
That is the only complaint. In that event, if this account and the money lying in this account is not protected, then how the investigation is to be carried out? Ultimately, if it is found that no, the allegation is correct and the offense is established, then how it is to
I'm deeply obliged. This is attachment, my lord. This is a classic illustration of attachment, my lord. What has fallen from your lordship?
Crossing a particular stage or not trying to answer the query of this court. The attachment is yes, where involvement of magistrate is required.
Right, my lord.
Order needs to be passed by the magistrate. But why under section 106(1), when the sole basis of the complaint is an bank account, which it is alleged that is the repository of proceeds of crime, and if that bank account is not seized or is not seized but it is not frozen, in that event, how the investigation is to be carried out?
My lord, I'm obliged, my lord. Apropos this, my answer is, my lord, the proceeds of crime, the term is conspicuously absent in 106 and the term is there in 107. So therefore, proceeds of crime.
If freezing of bank account is an ancillary issue along with several other issues, then I can understand. But it is the only issue that I have been cheated, and that's why 318 has been claimed. And the proceeds of this fraud is lying in that particular
Right, my lord, which is why there has to be 107.
And the amount is to the tune of rupees 2.41 crore.
Right, my lord. So
if that is so, then if that account is not protected, if this account is not freezed, in that event, there will be difficulty in
that freezing has to be in accordance with law, my lord. And the procedure is 107, my lord.
Procedural law, my lord, with great respect, my lord, is to advance the causes of justice.
And there is a specific provision interrupted, my lord. So therefore,
And
kindly appreciate the difference. One of the differences, there will be a magisterial intervention. My lord, today, kindly step back from this case, my lord. Give me 10 seconds. Suppose there is a murder, my lord. At broad daylight, we see this. But despite that, my lord, whatever might be the clinching evidence, this requires a trial and the procedure established by law has to be, my lord, undergone. Here also, my lord, if the property to be
in connection with an allegation, if the account is an addition, is an ancillary issue.
But that is one of the. This is an
here. It is the main issue. Here it is the only issue that the petitioner in private respondent in your petition was cheated to the extent of rupees 2.41 crore and the proceeds are lying in the account.
Exactly. So proceeds of crime in 107, my lord.
Protected.
So under 107, my lord.
Today, if this account is not frozen, in that event, this account will not survive till completion of investigation.
Right, but this has to be frozen in accordance with law, my lord.
2 crores already gone.
Therefore, my lord, the procedure has, my lord, this has to be frozen in accordance with law, my lord. Kindly appreciate. This cannot be, my lord, at the jurisdiction of the police, my lord. My lord, I have just 2 judgments of, my lord, this court, my lord.
2 crores already.
I just given my
elaborated,
lord, soft copy I have my
Can
lord.
you leave, matter will appear under the heading hearing, then you will rely upon the judge. Today I will not pass any order to
Or if I rely on only one judgment.
freeze the account.
No, perfect. You also can deal with this issue, my lord. If I may rely on this judgment, because if there was ultimate, my lord, defreezing, then I have a prima facie case, my lord.
Yes.
My lord, can I just rely on one judgment only, my lord? Only one, my lord.
Hard copy.
Lord, copy right now.
We'll put in our affidavits thereafter, my lord.
We are not disputing on anything on facts, my lord. We can come back tomorrow, my lord.
Let the matters be put on issues be put on.
My lord, then in the meantime, I'll be crippled, my lord. I cannot run the factory,
Put
my lord.
everything on affidavit.
Can you give, my lord, the judgment is exactly on this point, my lord. And it is staring at us, my lord.
Said that bank account is property.
Sir, please,
in terms of
Supreme Court has
120.
never interpreted 107. Please don't
supposed
let
to
us.
be.
No, that is not 107. Under the.
shout your
I am not
views out,
shouting.
Mr.
You are making
Bhattacharya.
inaccurate statement
My lord,
in court.
I do not want to
My lord, kindly seize
raise
this, my lord. If
voice
I
in
may just
court,
request this,
but
your
this is
lordship, my
really
lord.
not the way.
If your lordship sees this
This has
judgment, my
become
lord,
a difficulty now, my lord.
because you interject every time, my lord. Question is
now a
supposed to be.
difficult-
You are, my lord, if I may just request your lordship, beseech your lordship to see this. Only one, my lord. I'm so sorry, my lord. With deepest apology. Only, my lord.
Done.
Only, my lord, 3 paragraphs I'll be placing, my lord.
No, in that even Mr. Bhattacharya, you ought to have filed an intra-court appeal against the order passed by Justice
They
Ghosh.
have not challenged that order.
My lord,
there is another hurdle.
my lord, that
Today
order.
being a coordinate bench, how I can ignore that order? Because these steps were not taken by the police authority at the inception.
Right.
After this order was passed, this step was taken. Now, if you are agreed by this order, then you ought to have preferred an intra-court appeal
My lord, with deepest
against the
respect,
order passed by Justice Ghosh.
my lord, with deepest respect, I'm not agreed by that. I'm agreed by the way it was done, my lord. The mode and manner was never, my lord, mentioned by the honorable judge. What they have done, the moment, my lord, there is an order, they have, my lord, arbitrarily, they have seized my account, my lord, without being, my lord, empowered with that, my lord. So they are denuded of that power according to CRPC or BNSS, my lord, but they have done that. My lord, para 7, if I may request your
Just
lordship.
a circuitous
No,
way
where is
to
the
avoid
complaint first? Paragraph 7 will
Perfect,
come later on.
Para 2, my lord.
Come to paragraph 2.
Paragraph 2, my lord.
Place it.
Landed counsel appearing for the petitioner submits that the bank has freezed the account of the petitioner, and when the petitioner inquired, the same bank had forwarded the letter dated such and such, but identical to this, wherein the officer in charge of Itanagar police station, Arunachal, has directed the bank manager, HDFC Bank, to freeze the account of the petitioner, and in terms of the direction of the officer in charge of Itanagar police station, the bank has freeze the account of the petitioner. The learned counsel of the petitioner submits that on 13 January 2025, the petitioner has received a communication from the Assistant Commissioner of GST such and such Itanagar, wherein it stated that during investigation of such and such, the office of the Assistant Commissioner noticed that the said firm has passed an input credit to the account of the petitioner to the tune of 1,83,934. On receipt of the said communication, the petitioner has immediately sent a reply to the Assistant Commissioner, CGST and CX, informing the petitioner is no way connected with the Siddhi Binayak trade merchant and he has no transaction with the firm. After sending the said reply to the Assistant Commissioner, the petitioner has also reserved the amount of such and such back in the account of Siddhi Binayak merchant.
It relates to input tax credit.
So there is an FIR.
It relates to input tax credit. So therefore, and here the complaint is this, that petitioner has been cheated to the extent of 2.441 crores by the other directors of the company.
Right, my lord. So therefore, it is at the instance of a police letter of the police. The same was the fact. Then sees, my lord, it's on law. Absolutely, the law was decided, my lord. Sees then para, my lord, para 7 sees, and then para 8 is the law which was decided, my lord.
Sure.
Well, kindly consider my prayer. I will leave it to your lordship's discretion, my lord.
Two writ petition, civil revisional, criminal revisional applications are filed by whom?
My lord,
petitions. Your lordship was
there are quashing is by me, and one cancellation of bail against by my learned
Give your
friend.
lordship the sequence, if my friend will allow. First writ petition by me as the complainant.
Where Justice Ghosh passed an order.
Second writ petition by Mr. Bhattacharya seeking defreezing. There is a CRR where another accused prays for quashing of the proceedings. And there's a cancellation of bail application at my behest.
Another accused who is representing this.
I'm the petitioner. I'm the petitioner.
There's a cancellation application at my behest seeking cancellation of bail. But primarily today your lordship is hearing.
My lord, in
two read
CRR and CRA, my lord, no notice issued, my lord.
This CRM is cancellation.
Lordships.
That is at your instance.
That is at my.
In these matters, my lord, no notice issued as yet, my lord. CRM and CRR.
No. Two writ petitions, one criminal revisional application being 322, being CRR 322 of 2026. That is at your instance, revisional application.
I'm deeply obliged.
CRR 322 of 2026 and another application seeking cancellation of bail being CRM within bracket M556 of 2026 are taken up for consideration. Cancellation of bail at the instance of the client of Mr. Chatterjee.
Well, may I just take your lordship's leave? My junior will be. Can I take your lordship's leave? Most obliged. Most. And I'm deeply obliged for the patient hearing, my lord.
Mr. Chatterjee, what is the complaint?
Complaint, yes. Kindly take up my writ petition, my lord.
5826 of 2026.
No, my lord. 27942, my lord. 279. Page 37 is the formal part and 41 is the complaint.
My lord has got it.
Lordship wants me to place it, my lord?
No.
iPad.
Accused. Writ petition being WPA 27942 of 2025. Was preferred by one Amar Kumar Saha one of the directors of Authentic Tea Private Limited. He was one of the directors.
I was, but I was thrown out. That is my case made out in the complaint.
At the time of filing of this writ petition, you were not the directors.
No, at the time of file. No, my lord, kindly see the FIR, my lord. I say in page 41, I say I am a director, but then, my lord, I have said in page 44, or rather, my lord, page.
Very well, very well. One of the directors of Authentic Tea Private Limited. Alleging, no, limited. Taking necessary steps to be taken by the investigating by the concerned police authorities in connection with Vidhannagar police station. No, in connection with Newtown police station, case number 1086, dated 14 September 2025, under section 35/318/3/336/3/61/2 of BNS 2023. BNS 2023. Stop. On that writ petition, an order was passed by a coordinate bench on 17 December 2025, directing the concerned investigating agency to take steps with regard to the aforesaid criminal prosecution. Stop. Pursuant to the said order dated 17 December 2025, bank account of, what is the description of the account?
Well, it will be there in the report.
Yes, in your writ petition 5826 of 2025.
Paragraph number 7. Paragraph number 7.
7.
Let me tally it with the report of the state. ঠিক আছে, এটা তো ওরা বলছে
রিপোর্টটা খুঁজে পাই মুশকিল।
2 days report.
খুললাম রিপোর্টটা। বুঝছো? বুঝলে? এটা নয়।
My lord has seen the report too. My lord মার্কও করেছে।
Where is the description of bank account? In today's report, there is no description of bank account.
Lord, in their writ petition in paragraph 7, they have referred to the bank account. In their writ petition.
That is
Internal page 9, para 7.
Paragraph 7.
This is the account. কোথা থেকে জান?
হ্যাঁ, please. Bank account being number 77730 200000 3859, maintained with Bank of Baroda, Church Lane, Siliguri. Why it has been filed here? Why the writ petition has been filed?
FIR is in Bidhannagar. FIR is in Bidhannagar.
Oh, it is in Bidhannagar. Church Lane, Siliguri. was debit frozen. Debit frozen. Debit frozen. Prompting the petitioner company in WPA 5826 of 2025 approached this court with the writ petition questioning actions of the concerned police authorities. Such acts and actions of the police authorities. Stop. Next paragraph. Both the writ petitions, both the aforesaid writ petitions and criminal revisional applications as well as applications seeking cancellation of bail are considered. Stop. Next paragraph. Mr. Bhattacharya, Mr. Oyon Bhattacharya, learned senior advocate representing the petitioner in WPA 5826 of 2025 placing reliance on section 107 of BNSS 2023 submits that procedure contemplated under section 107 is not adhered to while freezing aforesaid bank account as such acts and actions of the concerned police authorities cannot survive. Stop. Next paragraph. Mr. Saurabh Chatterjee, learned senior advocate representing the petitioner in
The WPA 279.
Yes. এটাকে সরাও in WPA 27942 of 2025 relies upon section 106 of BNSS 2023 in order to substantiate freezing of aforesaid bank account. And in addition thereto, reliance is also placed on the order passed by the coordinate bench on 17 December 2025 in WPA 27942 of 2025. Next paragraph. BNSS 106 BNSS 2023. Next paragraph. Section 106 subsection 1 of BNSS 2023 provides any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offense. Stop. Since allegation is cheating and criminal breach of trust, consequently enriching the aforesaid bank account in question, court at this stage, while passing while considering prayer for interim protection, needs to take into consideration consequences of defreezing aforesaid bank account. It was also observed by the coordinate bench in the order dated 17 December 2025 that petitioner in WPA 27942 of 2025 lost rupees 241,50,000, which is the basis of initiation of aforesaid criminal proceeding, comma, if at this stage, now, if at this stage, defreezing of said bank account may frustrate investigation, considering complaint lodged by the petitioner in WPA 27942 of 2025. Stop. Next paragraph. Considering the provisions contained under section 106 and section 107 of BNSS 2023, act of debit freezing said bank account may not be in consonance with section 107 But why such action is contrary to section 106 needs further consideration, Lordships. Stop. Moreover, steps taken by the concerned police authority is steps taken by the concerned police authority in debit freezing the bank account is after the order was passed by the coordinate bench on 17 December 2025 on the writ petition being WPA 27942 of 2025 and against said order dated 17 December 2025, no appeal is preferred as it is submitted on behalf of the petitioner in WPA 5826 of 2026. So, the next paragraph. Therefore, prayer for interim order, thereby directing the concerned police authorities to defreeze the said bank account, is refused. Stop. Parties are directed to exchange affidavits by 4 weeks from date. Stop. Let the matters appear under the 4 weeks from date. Stop. Let the matters appear under the heading hearing in the monthly combined list of September 2026.
Lord, only one request, Lord, in the final finding portion where my Lord is refusing the interim order, whether my Lord will also be minded to record Mr. Bhattacharya's statement to court that as on date only 44 lakhs is lying. Because that is also one of the issues. And it is he who has said that only 44 lakhs is lying out of 2 crore 41. So it was not my statement, it was his statement.
Moreover, is refused বলে যে সেন্টেন্সটা হলো ইন্ট্রিম অর্ডার তার ঠিক আগে একটা সেন্টেন্স এড হলো। According to the complainant,
but not according to me, my lord. It's according to the petition.
Yes, you are the complainant.
I am the complainant. Yes, 2 crore 41 lakhs.
According to the complainant disputed amount involved, alleged involved amount is rupees 241,50,000, whereas it is submitted by Mr. Bhattacharya, learned senior advocate representing the petitioner in WPA 5826 of 2026 that at present
approximately 44 lakhs. Approximately 44 lakhs. 44 lakhs.
At present, approximately 44 lakhs is lying in the said account.
If Justice Ghosh would not have passed this order, these 44 also would have gone.
Report file be kept on record.
Yes, report filed on behalf of communication dated 13 July 2026 of Inspector in Charge, Newtown Police Station, Bidhannagar Police Commissioner is filed in court and same is taken on record.
I'm deep.
You decide. You decide whether you will use it or not on the next date. If you do not use the affidavit, that will be recorded.
All matters in the monthly list of September. Deep.
Item number 83. Wait, please, Your Lordship. I'm appealing for the petitioner. My lord, your lordship had the occasion to be. Well, this was with regard to the bank debit freeze in respect of the bank of
That matter?
yes. Now the debit freeze has been removed as per your lordship's direction. That amount which they had said of 2,300 rupees stands. They are marked as with lien. Now they were supposed to give a report.
My lord, I am appearing for the respondent number 5, Standard Chartered Bank.
Where is Mr. Das?
Hey, Dada.
Where is Mr. Das?
That I cannot say.
The
My lord,
report
perhaps
is required to be filed.
Court number 12. His junior is instructed. Court number.
How long this matter will be adjourned? Several orders were passed for filing a report.
And
no idea, my lord,
we had
as
been
I am
given
not engaged
notices
in
under
this matter.
35(3). Lastly, on the last occasion, that's in April, we have gone and complied with it also, handed over all documents.
Let it
After
be
that,
only
we have-
not today. I will instruct Mr. Sujuni
Not
Das.
today, Comrade.
Not today.
Not today.
Yes.
Item number 84.
Item 84, I am for petitioner before Lordship.
My lord, I am for the statement.
Yes.
But my grievance is, my lord, the private responded without having any right, my lord. They are, my lord, trying to enter into my and my lord trying to occupy the land, agricultural land.
Yes, report by the officer in charge, Murarai Police Station. Police is saying that the private respondents are in possession of the land in question.
No, my lord.
0.100 acre. And you do not cultivate the land.
My lord, that
If that be so, then the question of taking usufruct of the land does not arise.
yes, my lord, therefore I filed this writ application because my lord, I am
So
the
the writ petition that cannot be gone into.
no, my lord,
If you are the owner of the land, you have to assert your right by initiating an appropriate proceeding.
no, my lord, I am in possession. I am the recorded owner. I cultivated the land, my lord.
Police saying
My lord,
that during
when there-
inquiry, it could be learned that petitioner never cultivated upon his recorded land, and physically the private respondents are in possession of the disputed.
No, my lord, there have still, my lord, the petitioner cultivated the land, my lord. My lord, this report, my lord,
Pursuant to the order dated 17th April 2026, a communication dated 6th May 2026 of officer in charge Munarai Police Station is filed today and same is taken on record. Stop. Copy of the said communication dated 6th May 2026 is made over to the learned advocate representing the petitioner. Stop. It is disclosed in the communication dated 6th May 2026 that though petitioner is the owner of 0.0100 acre of land, but physical possession lies with private respondents and petitioner does not cultivate the said. Next paragraph. From the contents of the communication dated 6th May 2026, it appears that the issue involved in this writ petition is civil in nature, requiring the petitioner to approach the appropriate forum to assert his right over the said land in question. Stop. Next paragraph. However, concerned police authorities are directed to maintain peace and tranquility at the local and to see that no untoward incident takes place. Next paragraph. Writ petition stands disposed of. Parties to act on the server copy.
I'm getting much
Grateful.